having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everybody. Welcome to the Appeals Court for this session on Thursday, November 14th, 2024. We have 5 cases on for hearing today. I know many of you are familiar with our rules, but before I get to that, let me say I'm John Englander. To my right is Justice Hershfang. To my left is Justice Brennan. We're your panel for today. I know many of you are familiar with the rules, but we have 15 minutes to decide. We do not allow rebuttal. I can assure you that we have read everything very carefully that you've submitted to us, so best to get right to it, and I'm sure we'll have questions for you. The first case is 23P 1319 Commonwealth against, is it SETTE?
Yes, Your Honor.
And Mr. Kelly, welcome back.
Thank you, Your Honor. Good morning. May it please the Court, Brian Kelly on behalf of IURY SETTE. If the Court was wondering how to pronounce that first name, that's how you do it. This is a case, as you know from the procedural history, that the defendant had pled guilty, but there was an agreed upon conditional plea for which the defense was challenging the judge's ruling on the motion to suppress. Just as an initial matter, the government had filed a motion to include the 911 call, which I don't object to that inclusion, obviously, but I'd like to be heard a little bit later about what I think that evidence should be used for. The two issues on the question of consent, I think, are interrelated. That is, one, whether or not Mr. Figueroa had the authority to consent or apparent authority to consent, and then two, whether or not he actually or impliedly consented to the entry into the home. As the Court well knows, Mr. Figueroa was the one who called 911. Officers appeared from the Danvers Police Department and made entry into the address. And as the Court knows from the physical structure of the building itself, there's an outside door which was closed. If the officers then made their way up the stairwell, I believe the government sent to the Court supplemental appendix with photographs just to give you a flavor of what it looks like inside. When you reach the top of those stairs, that door, my understanding is, the credible evidence was that door was open. The officers then
Is there even evidence there was a door?
The front door, there was evidence that there was a front door to the...
Right, no, but a door at the top of the stairs. So, because I think it matters, right? I mean, the judge found that Figueroa lived in the, quote, unit.
Yes.
That there were no barriers to the upstairs, that there's only one kitchen and it's upstairs. You say, so would that be enough if those facts were based in the record?
Enough in what way?
To demonstrate that Figueroa could consent to a entry into the upstairs?
I would say no, Your Honor.
Really? Why? What more would be needed if there's only one unit and Figueroa lives in it?
Because I don't know that that's actually the credible testimony that was received.
Well, but that was my question. In other words, let's assume for a moment that those facts are based in the record. Would it be enough for the test, let's assume the testimony was Figueroa lived in the unit and there was no barrier to the upstairs and there was only one kitchen in the home. Would that be enough?
To the question of whether or not he possessed authority.
Yes, whether he possessed authority to consent to a search, if you will, of the upstairs.
Boxing me into a corner. I would say yes, somewhat with a little asterisk on the corner there.
Sorry about boxing you in, but I'm really trying to understand it.
No.
It's a fair argument.
It is. Well.
No, I mean, it's a fair argument, but I want to understand the limits of it. So your argument is that those findings were not supported by the record.
Yes.
Right? What's not supported by the record, then, of those findings?
Because of the testimony of the officers about what they knew, right? So, as the court knows, there's a difference between maybe what the 911 call was and what the officers knew when they showed up. And what the officers knew when they showed up, which was testified to, was there was, at the very least, confusing information about where exactly Mr. Figueroa lived that was not clarified by the officers.
Well, it was certainly a reasonable inference he lived in the ground floor, wasn't there?
Yes.
Okay.
There was a reasonable inference that he lived, the way I view the evidence is that he lived in a different space, because that's what the officers said. So then the question becomes, does he have the authority then, setting aside the question of whether he actually consented, does he then have the authority to consent to a different space, which is apparently upstairs?
What testimony, are you pausing? Done. What testimony do you think supports the notion that the officers testified that he lived in a different space?
On cross-examination, which was brought out, it's in the brief, Your Honor, that he says, when I cross-examined the officer, what I'd asked him was whether or not he lived in the same space or a different space. I may be getting that, not exactly phrasing that correctly, but the officer had agreed that he lived in a different space was his impression. And when I say different space, what I take from that was there was a separate unit that was down below. And I think the officer actually said that also in direct testimony.
I think the words different space are in there.
Yes.
I think that that's a separate unit down below. That's your characterization or interpretation of what different space means, right?
Yes.
Okay.
Yes.
Right, I think that was on page 47 or 48 of the transcript. I'm not asking you to look at it because I'm going to do a dramatic reading of it myself. You asked, so this is a multi-unit apartment building, correct? The officer agrees. And then you say, and as you've described, Mr. Figueroa lived in the unit below the unit that we're talking about. Is that correct? And the answer was no. The unit that we're talking about is it could all be one unit. There's a bit of confusion as far as who lived where. I believe that William stated that he lived downstairs. It could still be one single unit. He just lived separately downstairs through that one main door in the front.
Right. Right. And so we also talked about what was said on direct testimony, which was on the transcript, page 16 and 17, and where Officer Green says, this is in response to the district attorney's question, Mr. Figueroa is outside, period. He lives in that unit. Is that correct, Officer Green? I believe so. It might have been in the unit below.
Right.
So even on direct testimony, Your Honor.
So the thing that I'm taking out of this is that the use of unit at this hearing was pretty imprecise. But I'm not sure if that equates to you win, right? Because then what you're asking us to do is interpret the testimony in a different way.
Than what the judge did.
Yeah.
Yes. Yeah, but, so it's a high burden, right? I have a high burden here. I get that. I understand. But my issue with the way that the court found the facts is, and I think the government obviously has a different position, that somehow, some way, we can just ignore all the other testimony and just focus on one sentence that's taken out of, testimony and say, oh, well, he lived there, so he can consent. And he's not only consenting to, there are other cases that talk about, well, within a single unit, you can't necessarily consent to another person's space, and he's not even doing that. He's doing, what you could take from this is that there are two different units, and he's consenting to an upstairs unit. If he is consenting, he's consenting to an upstairs unit inside a bedroom. So that's the part that I think is problematic from the defense's perspective.
So just to follow up on that, assume for the moment, I know you don't agree with this, assume for the moment that Mr. Figueroa did live in what was essentially, or was, I'm not going to say essentially, one apartment. His bedroom was on the ground floor. Your client's bedroom was on the second floor, along with the kitchen and I don't know what else.
Yep.
Would Mr. Figueroa have had the legal authority to consent to the entry into your client's bedroom on the second floor? And if not, why not?
Because it's a different space, Your Honor, and there's a different expectation of privacy, I would suggest to the court, having no law at my particular fingerprints.
Of course, my next
tips.
question.
I believe there's a case cited within our brief about similar circumstances where the court has found problems with what the scenario you're talking about. And obviously what we're dealing with here is, again, not conceding that he actually did consent, but just the space itself, the reasonable expectation of privacy. Because as you know from listening to the testimony and looking at the transcript, you know, the cops don't just go in and say, oh, you know, okay, we can see what's happening, let's get everybody out of here. They remain for a period of time, which I think is also problematic.
So let me ask you about that, okay? Yeah. And I'm not being facetious at all, but sometimes I try and look at these from the other end side as a starting point, which is what should they have done differently?
Knocked on the door.
And is this, in your view, a thanks for sharing, have a nice day, and hope no one gets shot?
Knock on the door.
Well,
No. Once they're inside and they hear people arguing upstairs and they're told that they're fighting about a gun, and it's a report of a domestic issue that involves a gun,
right.
How could any responsible police officer, when it then is met by the person who made the report and said they're fighting about a gun upstairs, big silver gun, say, oh, okay, thanks so much, good luck?
And I
just don't see that. So what should they have done?
So this is the classic example of how to properly conduct law enforcement, but also make sure that we have safety, right? And we know from the case law that just having a gun isn't necessarily a crime, right? They didn't clarify whether or not anybody had a license. They didn't figure out who was actually living where. They could have asked that everybody leave or clarify who lives here, who's.
Hang on. There was a fight involving a gun upstairs.
Yes.
And it's a domestic violence call, which under Gordon, which is appellate court case, is an important factor, given and I think the judge cited it, given the public policy about keeping folks safe and the potential for escalation in domestic violence situations, right? And so they're right there at the door, and they're being told there's a fight involving a gun upstairs.
I'm going to push back just a little bit about the word fight, because as the officer testified, it could have been just an argument. And that's why it's important that the difference between...
But the word fight was used. They're fighting over a gun. Right. So if you're the officer, don't you at least have to take as a possibility that they're literally struggling over a gun?
But that's not, Your Honor, that's not what was testified to by Officer Green, who was the person responding. He agreed and acknowledged that it could have been an argument.
So we've morphed from the consent case to the to the emergency aid exception.
Right. We're off
We're
track.
talking about the emergency aid exception now, and I would like to hear from you about the 911 call on the consent issue, but let's talk about emergency aid since we're there. I mean, what he knows is there's a, quote, fight over a gun. As Justice Brennan asks, okay, so the question is what would a reasonable officer believe they need to do under those circumstances, right? Words to that effect. I don't have it exactly right, but that's roughly the test.
Yes, Your Honor.
And your argument is they can't go inside the house.
That is my argument. That is my argument, because as they appear, okay, now again, we're talking about what I believe to be two different pieces of information. The 911 call has much more information than what the officers testified to at the motion hearing. So what they know when they appear is there's a fight over a gun with the officer. Again, acknowledges that it could have been just an argument. They don't know when anybody's licensed in the house. They
could have been a fight too.
Could have been a fight too. But why isn't it appropriate to put on, first of all, ask the person who's standing there, what's going on? You know, and they don't do any of that. They have a brief conversation with them and go right in the unit. There's no knocking, there's no ringing the doorbell.
They don't need to knock on the front door because the guy who lives there is, so now I'm back on consent. The guy who lives there is standing out on the porch telling them what's going on. So they don't have to knock on the front door. And we don't know that there's a door on the upstairs because, in fact, the pictures that I saw suggest there isn't. And that would have been in evidence before, is this Judge Barrett? Do I have that right?
No, Buxton, I think.
The cases that, I've seen about this exception have a lot more information. In the case about the dogs and you know, the police appear and their dogs on the lawn, and the dog is literally dying. And
Maybe so, but it's awfully difficult sitting here when we're talking about whether, fundamentally, the question is, was what they did unreasonable? That's the word in the Constitution,
agreed.
right?
Yes.
And boy, it would seem unreasonable to me not to go upstairs.
This is where we just, I think, disagree a little bit, because I think that the question, there's no threats, right? They're arguing or fighting over a gun. And they're just
Sufficiently enough so that this person felt that it was necessary to call the police.
Right.
And the last word of his 911 call is please, right?
I agree, yes. Does the officer know that when he appears? I don't think so. I think what he knows is
And that gets
important.
into the Previtt case, which is
That's
what you
correct.
wanted to talk about off the top, right?
A little bit. I did pull up this particular, because in my view, this is almost like a post hoc analysis that the judge could have thought X, Y, Z, but to me, it's what the cops knew, what the police officers knew when they appeared. And I just took a quick look at Previtt this morning to think about, you know, so under
Well,
Article
first of all, let's
14.
just stop for a moment, because there is information in the 911 call, apparently, that goes to consent. Is there information in the 911 call that you find troubling for the purposes of an emergency aid situation? I guess the word please. Yeah, okay.
It's just what to me, the difference is what the officers knew versus what was contained in the 911 call. And you can get that from the transcript.
And you're going to argue that under Previtt, the 911 call, the information in the 911 call can't be attached to what the officers knew at the
Unless it fits within this Previtt case, which, to be consistent, I'll just quote it, to be consistent with the requirements of Article 14, in order to aggregate officers' knowledge, the officers must be involved in a joint investigation pursuing a mutual purpose and objective, and that they must be in close and continuous communication with each other about that shared objective. And to me, having done this motion, and you can listen to the turret conversations, that's not what's happening here. The officer, I mean, it's quick, I acknowledge that, but they don't have all of that information that's contained in the 911 call.
briefing in this case was done before Previtt, right?
It's in the appellate, well, it's in the appellee's brief, so, in a footnote.
The 911 call, though, was not provided until, or at least the Commonwealth didn't submit it until this week. So I just wanted to
Oh,
have
but that doesn't
But it
matter.
was, yeah, wasn't it in evidence at the hearing?
It was in evidence. I'm
Well,
not
so-
objecting to it, but that's why I'm late responding to this issue.
Okay. We understand your argument.
Thank you.
And we'll hear from the Commonwealth. Thank you.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the motion judge properly denied the motion to suppress in this case, where he properly found that the police's entry to the 911 caller's residence was consented to, and where there was an emergency exception to the search warrant requirement. I do not think that this court can properly find that there was that the finding that Mr. Figueroa lived at that residence was clearly erroneous. The finding can be supported.
Well, lived at that residence doesn't get you there, though, does it? I mean, there's no question he lived downstairs, but was there any evidence that he had access to the upstairs? And if so, as Justice Hershfang points out, is there anything that suggests that that even if he had access to the upstairs, he could walk into the bedroom of the defendant?
Well, I think the case law is that a co-inhabitant can freely give consent to search the premises. So I think
No, that's not the case law. The case law is much more nuanced than that, because if, for example, there's closed doors within a cohabited residence, then you're going to need more than just the fact that they're cohabitants.
right, but I think in this case the issue was whether he lived there. That was the whole issue in the case,
Well,
and whether it was one.
Is it? I mean, the defendant says, you, the Commonwealth, need to prove that you had consent to perform the search that was performed.
Sure, and the issue at the hearing was whether this was one unit or 2 units or potentially 3 units. And the judge actually did some questioning of the responding officer and asked him, is this a multifamily, and how is the building divided? And the officer was clear that there was a front unit and a back unit, and that they had responded previously to the back unit, and that this case only involved the front unit. And the door to the front unit was open, and where Mr. Figueroa was standing, greeted the police officer, basically told him the same facts that were in the 911 call, that his family members were fighting, that he had seen the family members fighting, which suggested he had personal knowledge, that he had personally seen them fighting, where they were still fighting, and then the officer heard the fighting as he went up the stairs. So I do think that it was not in error for the judge to find that Mr. Figueroa could freely and voluntarily give consent. And I would point out that the officer didn't go directly into the bedroom. The officer went up the stairs as he heard the fighting, was in the kitchen and looked over, and the parties were in the bedroom. He asked the parties to come out to the kitchen, at which point he was in the kitchen speaking with the parties. He was speaking with the parties, asked them about the gun. They denied having a gun. He went back downstairs, talked to Mr. Figueroa, separated one of the parties, went back upstairs, asked to speak to the aunt, I think, then brought the aunt into the bedroom, and it was the aunt at that point who directed him to the dresser drawer where the 2 guns were found.
You said brought the aunt into the bedroom. My memory, but I may well be wrong, is that the officer and the aunt went into a different bedroom, not the defendant's bedroom.
Correct.
Okay. So at this point, when the officer recovers the 2 guns from the dresser, has he ever stepped foot in the defendant's bedroom?
I don't think so, Your Honor.
And one of the guns that he recovers is a big silver gun, correct?
I honestly don't know. I can't remember, I'm sorry.
I don't either, but presumably we can figure that out. So at that point, the officer has, as far as he knows, he has accomplished what he came there to accomplish. He's found a big silver gun. The parties are no longer fighting over it.
True, but also at that point, he has probable cause, which is what the Commonwealth
Probable
argued.
cause for what?
Probable cause to believe that there's
Or other guns?
No, probable cause to believe that someone in that house is possessing illegal firearms.
That gun.
Yes, and the other gun that was in the dresser drawer that he saw.
Right. I guess what I'm getting at is the part where I kind of run aground, but neither of you argued it, so I may just be running aground all on my own. That happens. Is that then the officers go into the defendant's bedroom, not for any apparently nefarious purpose. They're just trying to get a quiet spot. And then in plain view, they see guns that they had no reason to believe would be there, or no expectation of finding. And I trust that those guns also are part of the suppression motion?
Yes.
So how is that situated? How is that discovery situated with respect to the 911 call about the big silver gun and the entry into the house that did not previously include an entry into that room?
So the officers only needed to be there lawfully in order for them to see what they saw. So
Right.
the consent that Mr. Figueroa gave consented to a search of the upstairs, and there's no suggestion that the doors were locked, that they were shut, that Mr. Figueroa didn't have access to that whole apartment. In fact, I would suggest where he lived there, they were his close family, I would suggest that he did have access.
Yeah,
And
there are
furthermore-
cases about bedrooms. I mean,
Yeah.
I wrote a case called Commonwealth against Hernandez, and in that case, cohabitant lived in the bedroom where it was found, and that was why it was okay. But there are cases about bedrooms.
But the police weren't searching the bedroom. They were simply in the bedroom because they needed a spot to figure out what to do next.
And when they came up the stairs, I think the testimony, again, tell me if I'm wrong, I think the testimony was that the residents were in the bedroom, I should be more specific, the defendant's bedroom is where they were arguing.
Yes.
and that the officer saw them in there arguing when he came into the kitchen, which seems to me to create a very strong presumption that the door was open,
Yes, I think
the
that's fair.
bedroom door.
Yes. So, sorry.
I was going to, can we flip over to the emergency aid? So on the emergency aid, the best case that your opponent has is the Arias case. So how would you distinguish Arias?
Your Honor, this is a domestic violence situation just where there's a report, a credible report by a person who lives in the home calling on their own family members. He is distraught on a 911 call, so I think it's inferable that
I'll put a pin in that, because we've got to talk about that.
But I think it's inferable that
Without relying on the 911 call for a moment.
Well, the judge relied on it was entered into evidence. I'm not saying that the police officer knew that, but I'm saying that it's inferable that he was still distraught when the police arrived. So you have a distraught family member telling the police they're fighting, my family members are fighting over a big silver gun that shouldn't be there. Please help, essentially. He's at the residence. I don't think that there's time in this situation. I think it's absolutely objectively reasonable to believe that there is a person in that apartment in imminent danger of physical harm.
Are you conceding that under Previtt, the horizontal collective knowledge doctrine doesn't apply here between the dispatcher and Green?
No, I don't think, I'm not conceding that because
Okay, so tell me why we can impute the information that was on the 911 call to the police on scene, the specific information.
Because I think we have the turret tapes demonstrate that there was actual communication between the dispatcher who received the 911 call, putting out the call.
What do you mean by turret tapes?
So we have, I'm sorry, go ahead.
I believe, Your Honor, on Exhibit 1, there's the radio dispatch between
Is the dispatch in evidence?
Yes.
It is?
Yes.
And the judge listened to it, and
Yes.
the calls back and forth then are on there?
Yes.
So they put out the initial call, the officers respond, there's more information, there's more response?
Yes.
Because
Okay.
I didn't notice that. I noticed that the judge indicated that the 911 call itself was in evidence, but I didn't know that the dispatch was in evidence.
It's my understanding that it's part of that Exhibit 1.
Which
Okay.
hopefully we're going to get.
Yes. I apologize, I did not
That's okay.
send it sooner. So I do think that you can attribute the 911 call. I think it's part of the record. I think it's part of what the judge could rely on.
Well, it's not a matter of whether it's part of the record. It's a matter of whether it fits Previtt, and we'll have a little talk here before you guys are done about whether we should have a couple pages on that. But, I take it your argument is, look, these folks, Previtt is about working as a team, and when you have a situation where you have a 911 call followed by a dispatch, followed by a response to the dispatch, they're working as a team.
Yes.
And that information should all be horizontally available for purposes of evaluating the reasonableness of the officer's conduct.
These aren't two disparate detective units that are, that happen to be investigating the same drug suspect. But I really don't think you even need it, though. I think the testimony alone establishes an objectively reasonable emergency. Once the officer heard the fighting, which confirmed the 911 call, was he supposed to yell at?
Hear the fighting till he'd entered the house. And it's the entry into the house that's the question whether that's lawful.
Well, I think absolutely that Mr. Figueroa could at least consent to the first door, and I don't think that.
Oh, wow.
To the downstairs where he lived?
Right.
And then you're saying he was shouting? Okay.
Right. I mean, this is, a law school exam maybe. But here he is, he opens the door. There's no evidence that he had to actually open the door, I don't think. There's no evidence that front door was closed. The testimony is that, and there's a photo of the front of the door with the door open. It's clear that the upstairs door was open, if there was one, but there's no testimony one way or the other about the downstairs door.
Can I ask, I'm sorry, did I hear you argue, and if not, is it your position that once they have recovered guns and confirmed that no one, at least of the 4 folks that are in there, are licensed, that they then have probable cause to arrest, at least somebody there, And does that then authorize them, short of just wandering into a bedroom, to actually do a protective sweep of the area?
Yes, and that's in fact what the Commonwealth argued below. The motion judge didn't find that that supported the entry because he explicitly said the probable cause didn't arise until the
Specific entry into that bedroom. So that's a different issue to me. It's a different layer of it, that once they're in, assuming they can get in, and then they find the guns, assuming they can find the guns, and they ask the questions, and everybody says, nope, we don't know anything, and then they check and no one's licensed. Right there, right, seems to me there's probable cause.
Yes.
Is that a different chapter, separate chapter, that then says they can do a sweep of the kitchen, the open bedroom, the other bedroom, just to make sure there's no weapons lying around, aside from just wandering in to make a phone call?
It
Is that
could
your
be.
position?
It's my alternative position.
Okay.
I still think that the emergency exception supports the officers being present where they were, and they needed to take control of the situation, and they needed to take control of the situation in a safe way. And they were being deliberate and thoughtful, and they weren't slapping handcuffs on people, and they weren't.
But once they found the guns, okay,
Which guns?
the two guns that were in the drawer in the mother's bedroom.
Yeah.
So they chased the information to the point where they were told the guns had been given to the mother. They then go into the mother's bedroom, they've got the guns. Why isn't that the end of the story?
It should have been, except that when they're trying to figure out who they should arrest, if anybody, how to secure the scene, they're seeking advice from their superiors. They necessarily needed to make a phone call apart from, I think it's in evidence that it's a small apartment. They step into a bedroom to make a phone call, and in plain view, they see the other guns.
There's also evidence at that point that the guns are the defendant's, so perhaps they have probable cause to search his bedroom. Okay. Anything else?
No, thank
It is
you.
a bit like a law school exam.
And you don't, just so clear, you don't, I can look at it. My memory is they didn't find, the guns they found weren't silver, but I might have missed that. It's in my notes, but I don't know where I got it from. I'm trying to find it. You don't have a specific memory?
I don't, Your Honor, I'm sorry.
Okay. All right.
Is there anything else you want to talk?
Thanks.
What do you think of that, 2 pages each? Folks, you each are granted the ability to just file 2 extra pages on Previtt and its application under the circumstances if you'd like to.
You're welcome.
And
Talk about a law school exam.
is 7 days?
Sure.
Okay.
Thank you, Your Honor.
Sooner if possible, but thank you. That's what I think. That's what I think. Yeah, exactly. Exactly. All right, the second case is Commonwealth against Carter, 24P 349. And Ms. Corey?
It's Allison Corey for Mr. Carter. So I'm not going to touch on argument number 1, the burden of proof, unless later, if you have some questions. I'm obviously just preserving that for further appellate review because of precedent. So getting into argument number 2 about the reliability of the hearsay
Could you
at the
get
probation hearing.
yourself a little closer to the microphone, please? I
Sure.
want to make
Sorry
sure I
about
can
that.
hear you.
Yeah.
Thank you.
Can, before you jump, was the argument about clear and convincing evidence raised before the Superior Court?
The sufficiency of the evidence?
No, the argument
I'm
that
sorry.
clear and convincing evidence was required and was the proper standard.
It was not.
Okay. Did it have to be?
Well, it is a constitutional issue, raises a constitutional due process protection, and it is fully briefed, so I think that it it's ripe for review, even though it wasn't raised at the trial level.
Okay. Is there a law that says that any constitutional argument of this type is immediately raises a substantial risk of a miscarriage of justice? Do you know?
I believe there is case law that says even when an issue is not raised at the trial level, if it is of constitutional importance, that it can be heard and decided, which will be maybe in a future forum. We don't know.
Okay.
Okay.
Thank you.
Getting to the substantial reliability. The violation at issue in this argument is the issuance of a new criminal complaint. That criminal
Can I stop you for a moment? I knew you really got your, because I want to take exception perhaps to one, I'm reading on page 20 of your brief where you say, Massachusetts District Courts routinely find that the existence of a new complaint is sufficient evidence to find a violation of probation. And then you put a little mathematical equation. And I have never gone there so far in this job, but I will say I spent almost 20 years as a district court judge. And I counted up, I probably did between 10 and 20,000 probation violations, I think, or thereabouts. Granted, 95 to 98% are probably admissions. I can tell you in none of those was new complaint plus probation equal probation violation, and I'm pretty sure most of my colleagues on the district court at that time didn't. Probation plus new complaint equals notice of violation, perhaps. So just before you throw out anecdotal equations, unless you want to tell me how you arrived at that particular one.
I say, good for you, Judge. That's
I'm not looking for
fabulous.
a pat on
In
the
my
back.
experience in the district court, 30-something years, it is fairly
If they don't look at police reports,
unfortunately.
if there's a hearing, if there's an evidentiary hearing, judges don't look at police reports.
A lot of times.
They just say, here's a complaint, that's a violation.
A lot of times, defendants will stipulate
No, I get
just
you.
on
So
the basis that they're,
98% probably are admissions to violations.
because there is a new complaint, it exists, it's public record.
But that's an admission, which presumably involves a colloquy and the defendant admitting to facts.
Yes,
We're talking about
yes,
hearings
yes.
where
So-
it's challenged, and you seem to be suggesting that the judges don't look at police reports or.
Oh, what
and-
I hear is even more. I hear you saying, you could stand up and say, Your Honor, I want to be heard on this. They need to submit some evidence. This isn't true. He didn't do it, or she didn't do it. And the judge says, no, the complaint's enough. Or the judge just says, well, see you later. I'm not going to listen to you.
Yeah, it's
Is that what happens?
It's an unfortunate reality. It happens.
Is that
too
what
often.
happens in your experience? That judges will refuse to hear from the defendant challenging the existence of the criminal act?
Well, remember, we all will remember, a defendant basically cannot testify as to a new complaint or the facts alleged in a new complaint at a revocation hearing, because if he says something wrong, it will be prior testimony recorded.
You say they need to put on evidence, right?
Oh, right, and the
The
police.
judge says, I don't need it because the complaint's enough?
The police report will serve to,
There we
bolster
go.
the complaint.
Or as evidence, perhaps, if substantially reliable. Hearsay.
Yes.
Okay, go ahead.
Brings us to your second argument.
Thank you.
Okay.
And the thing I would like, that would be helpful to me about your second argument is if you could distinguish Commonwealth versus Costa, which you cite in your first argument, but then, unless I missed it, which happens, don't really take on when you're talking about the Hartfield factors. And, Costa says, to my eye, explicitly that the other indicia of reliability doesn't need to be extrinsic to the hearsay in order to corroborate the hearsay. So internal consistency among statements made, in this case by the child victim, and description with a high degree of factual detail, which again, those of us who have watched the interview can draw an opinion about, can be corroborative. Why is that not fatal to your argument that the absence of extrinsic corroboration rendered this hearsay unreliable? That was a really long sentence. Did it make sense?
There are cases, every case we have reviewed where hearsay is the sole basis, there has been corroborating evidence.
Okay.
There are also cases that say otherwise.
Well, but Judge Hershfang's right on the money. You probably familiar, know Costa pretty well. Even though there's nothing that the holding is essentially sufficiently reliable without specific corroboration, right?
That's a question in the circumstances of this case.
I heard you to be arguing that there had to be corroboration. I think you just argued it again. And okay, and you did not make below the second Costa argument. You did not say, hey, we haven't been able to put on a defense because I've subpoenaed the victim and the victim has to come and testify. That argument was not made, right?
I don't believe he made it. The judge, I think, found good cause for not calling the complaining witness because he was a young child, etc.
No argument was made that there was not good cause. No subpoena was issued. I didn't see any of that. I didn't see what we dealt with in Costa.
No. The
Can I
Commonwealth.
ask you, assuming, I'm sorry, did you finish?
Just-
Assuming that corroboration is required, do you have a view as to what type of corroboration? I know Judge Wren didn't actually address it, but when I looked at the police reports, you had the child saying that he was at his grandfather's visiting, and the defendant lives with my grandfather. And then the mother says the child visited the grandfather, and the defendant is the grandfather's roommate. You had the child say, in a police report that's part of the evidence, the defendant lives at the bottom of the stairs and my grandfather's upstairs. And the police officer writes in the report, I confirm the setup of the house consistent with what the child said. Why is that not corroboration, at least of some details, if not the act itself, which it would seem to me in a non-invasive touching with only two people there is virtually impossible to corroborate.
True. What I have in mind would be along the lines of, okay, we're not going to have the child come in. I'm not even arguing, I'm reasonable. There was good cause. What about the mother, the interviewer? The mother could have corroborated by saying, I noticed a change, or he was quiet, or something, not the out-of-court statements of a non-testifying witness, something in addition. That's what I had in mind. There were witnesses available.
It's an affirmative obligation of the probation department to put those witnesses on absent a summons by the probationer. Is that the position?
I don't think they even summoned.
Right.
So it sounds to me like you are proposing that adequate independence corroborative evidence. God, that's horrible. I'm going to start that sentence over. I'm sorry. It sounds to me like you're suggesting that it would be adequate corroboration for someone to testify as to the child's body language or behavior in the wake of the alleged incident. Do I have that part right?
That would be.
So in that case, why is it not adequate corroboration to watch the same interview in which any viewer of the recorded interview can see the child's body language while being asked about these things. I'm not talking about the hearsay. I'm not talking about testimony. I'm talking about physical behavior that a judge can see with their own eyes as opposed to having someone describe physical behavior to them.
Because the corroboration is not the fact of the person repeating what was said, but the corroboration would be somebody who saw a change. So just viewing, we don't know what the child was normally like. That's why an actual witness who could provide corroborating witness to some
Why isn't that opinion testimony?
Not really, Your Honor. It would be more actual observations. My child was friendly and outgoing, played. My child came home and was quiet and withdrawn. To that. But I'm so low on time. Could we go to my third argument?
Please, yeah,
Thank you, which is,
the residence issue.
of course, right. So, the document itself says change of residence, okay? This man temporarily left his residence because he had to, okay? He did what he was supposed to do. But we can't say that that constitutes a change of residence because...
So just so I understand, so if someone, again, for at least at that point, an indefinite period of time is required to leave one residence and go someplace else, you don't believe that that's the registration requirement includes calling and saying, hey, I'm living here?
If we knew that the restraining order was going to be extended, absolutely.
So
But
for that
here-
10-day window, minimum 10-day window, then it's okay for the,
Temporary.
no, but it's okay then, all right, so that,
But how do we know it's temporary? So you put you put the rabbit in the hat with the word temporary right in the first sentence of your argument. We don't know it's temporary, do we?
At the time of the move, that is temporary because, and it's temporary because nobody can say it's going to be permanent. Something is either permanent or it's temporary. We don't know if it's going, let me say we don't know if it's going to be permanent.
Well,
Okay,
so,
because,
well, let's back up, because I'm not sure what we're arguing about. So, I agree with you that the condition is that he must disclose his change of residence, that's okay. And that's the probation condition. And so the question is, did he change his residence when he has moved to a hotel for 5 days, and he does not know how long he's going to stay there, right?
But suspects it may be a while because he's inquired about monthly rentals.
the actual evidence, the uncontroverted evidence would be the receipt showing 2 days.
No, there's more evidence than that.
Well-
We know he's been there for 5 days based on the evidence, I think. I really don't think,
Let me throw this out. Let me throw this out. I have to move for a couple days because my house is being painted. I haven't changed my residence, even though I don't know how long it's going to be, okay? This restraining order was a big question mark. Did it even qualify when they weren't household members? So this isn't just, a...
Right, but who has to know that? I mean, what's the purpose of the condition? The purpose of the condition is he's a sex offender, right? And we want to know where he is.
Where he is for the statutory amount of time, where he is residing. Not where he goes to visit somebody for 2 days. Not where, in fact, the probation order is change of residence, not change of address.
I got that part. Okay, thank you for your argument. Thank you very much for your well-presented briefs.
Okay.
We'll hear from the Commonwealth.
I apologize for the informality of my sneakers, in case anybody noticed. I had to wear them.
Did not notice.
No worries.
Ms. Kennedy?
May it please the Court, Ian Kennedy, Assistant District Attorney for the District Attorney's Office for the Middle District for the Commonwealth. This Court should affirm the hearing judge's order revoking probation and imposing a sentence of 4 to 5 years on the defendant. The judge correctly exercised his discretion when he found that the hearsay regarding the complainant's statements were substantially reliable and allowed them to be admitted at the probation violation hearing. And
Can I ask you this? Can I just jump ahead and sort of go backwards?
Certainly.
Can you take up the "my house is getting painted" argument? Because it's an interesting argument. Well, I don't know how long I'm gone for, but I'm going to be out of the house at least for a week or so. Do I have to report that to probation every time I'm going to visit my cousin?
I think there's a distinction here between my house is being painted and what happened in this case. If you want me to address the what my house is being painted argument, I can.
How about just why a temporary order that requires vacating the residence for 10 days is a change of residence?
Because a residence is not a domicile. A domicile is your permanent address. The case law has made clear that you can have more than one residence. And in circumstances like this, where, yes, I'm moving to have my house painted for a significant number of days when I am on probation for being a sex offender, yes, I think at that point you do have to.
Goes away for a weekend to visit friends. Does he have to notify of a change of residence?
But he's visiting with the intent at that point to return. There is this record, given what the question is whether the judge was warranted in making the findings about the change of residence.
Well, the judge didn't make a finding about a change of residence. She's right about that, isn't she? Your opponent, she says, the judge talked about a change of address. That's the only word he uses in his findings. He doesn't use the word residence, and the significance of that is never argued.
The significance of residence is argued. It's just, I think, what happened in that case is they were using the terms residence and address interchangeably. Even the probation officer used the term address during her testimony at times.
Okay,
So-
but the word in the condition is residence. What you needed to prove was that he had changed his residence.
Yes.
What he had done to that point was leave for 5 days because there was a court order that was only 10 days long that said you need to leave, right?
But that's not the only evidence that was submitted to the court. The other evidence submitted to the court was that in the police report, when he went in and spoke to the police, he told them he moved to the Copper Lantern. When the police went to speak to the owner of the Copper Lantern, the owner explained that the defendant had been living there and, in fact, inquired about a month-to-month lease.
His use of the term moved, which, of course, we don't know because this is second-level hearsay, whether he actually used the term moved. But you would say if he used the term moved, that makes a difference. Combined
with everything else, yes. Combined with the fact that when they went to the Copper Lantern and he inquired.
Is this sufficiency of the evidence review? Is that what we're engaged in?
I believe so, yes, but it's the standards preponderance, and the question is whether the judge was warranted in making the findings he did.
And is it a Lanigan? Is it a Lanigan review? In other words, it's just a
A
sufficient.
Lanigan? You mean?
Yeah,
Do you
to
mean
draw all
Lattimore? I
inferences.
apologize, Your Honor. Do you mean Lattimore?
I'm sorry, yeah.
Yeah, that's what threw me off for a second. I apologize.
And I don't blame you for being thrown off. You're absolutely right. Lanigan is a different animal. Lattimore, yeah. Is it a Lattimore analysis?
I believe the evidence should be looked at in a light most favorable to the Commonwealth. In that respect, yes, because the question is whether the judge abused his discretion and whether he was warranted in making the findings. You might have made a different finding, but that doesn't mean that the judge in making his findings was abused his discretion when he did so.
Well, unless he used the wrong legal standard, and he keeps using the word address, so I guess that's something we have to think about.
Well, when I think
Let me
of...
ask you another question. I
Certainly.
apologize. I apologize. I know I'm interrupting you.
It's your job.
Well, we have to understand it. That's basically what it finally comes down to. Let's assume that we disagree with you on this issue, but agree with you on the other issue. What should we do?
Well, I think you should affirm the judge's decision.
So even though he made an error with respect to one of the two grounds that he found, we can still affirm?
You may still affirm, or you are capable of remanding it for him to resentence based on your decisions. But given what the other issue is, which is that he reoffended by committing an indecent assault and battery on a child under the age of 14, I think the sentence of 4 to 5 years is warranted in this particular matter.
I'm just wondering if there's any case law on that where a judge cites more than one ground for violating probation, and some of the grounds are upheld and some of the grounds are held not to be sufficient.
Now, I hadn't considered this, but going back and forth with you, I do think that the best remedy at that point would be to remand it to the judge to resentence, but I still think he would be entitled to resentence to 4 to 5.
Of course.
I don't know off the top of my head any case in which that situation occurred.
If the judge used the improper term of, if he did improperly use address as in his findings, are we precluded from looking at the evidence saying, well, regardless of the term used, this is a change of residence? Or do you think we're stuck with the finding itself?
I think that you can look at it. I don't think when you read, to me, when I read the transcript, I look at it as the term address wasn't being used in a legal context. I think he was using it interchangeably. I think it was being used interchangeably with the word residence. And I do think that, that confusion is pretty easily clarified. It is a residence, and with respect to that, the residence doesn't have to be an address. It can be something in which the defendant has stayed for some time and plans on doing so.
Thank you.
Okay. I want to talk about the sufficiency of the evidence of reliability with respect to the hearsay evidence that formed the basis for the other finding?
Certainly, Your Honor. Before I begin, though, the only thing that counsel challenges in their brief is whether the evidence was substantially reliable. Does not challenge that if it was substantially reliable, the evidence was not sufficient to violate the defendant. So with respect to that, I think that it's important to note that there are 7 factors that were set forth in Durling, but I think Hartfield kind of really solidified what those factors were. The judge applied those factors to determine whether or not the SANE interview, as well as the complainant's statements that were in the police reports, were substantially reliable. He made extensive findings on the record, which he is allowed to do with respect to that. One thing that I would like to point out, this happens when I was preparing for oral argument, I came across a case cited by the defense counsel that emphasized the special characteristics of a videotape in the context of a SANE interview. I did not cite this. I should have. It's Commonwealth versus Patton, 459 Mass 119. And it states, with respect to a SANE interview, a videotape possesses certain special characteristics, including the precise words used by the child and display of the child's demeanor, as in that case, she related what happened, which added to its reliability. It's one of the arguments I do indicate that veracity was clearly shown, given the fact that the judge was able to view the videotape, which he indicated he viewed several different times, and it is from different perspectives. And so when you look at just the same interview itself, it exudes, in my mind, substantial reliability. There are very few leading questions. The only time there's a leading question is, what I noticed on the interview is when it was almost as if the interviewer wasn't sure if that's what the little boy was saying, because he had his head down, he was coloring the whole time. The interviewer was coloring the whole time too. This was not an inquisition that would have given the appearance that the victim, that the complaining witness in this case was being forced to say things. It was very open-ended, and the judge's decision to say that that testimony was, that hearsay statement was substantially reliable is supported by the record. I do want to point out something that Justice Brennan indicated with respect to corroboration. I do believe that there was some corroboration of that fact that the defendant lived with the child's grandfather and the setup of the unit. I disagree with counsel that the lack of corroboration alone is sufficient to say that hearsay is not substantially reliable. I think the Costa case makes that very clear.
Do you want to talk at all about clear and convincing evidence? Commonwealth ready to deal with that?
I can deal with it, but I don't think this court has the ability to do so at this point.
Well, then you might get me in a debate about whether we're bound by the Constitution. But in any event, for now, you've made the argument that this is the standard that the court has said is preponderance. But isn't clear and convincing the standard that the court has sort of repeatedly taken on in the last, I'm talking about the Supreme Judicial Court, in the last 10, 15, 20 years for issues where there's substantial deprivation of liberties at stake?
Well, with respect to this, when you're talking about a substantial deprivation of liberty, it's conditional liberty. This is not a situation where someone, this person has already been convicted by the Commonwealth.
Yeah, and I take the bitter with the sweet, right? That's your contract. Your contract is, we'll let you go, but you can be sent back to jail based on a preponderance standard.
Exactly, and actually, you referenced the term contract.
The United States Supreme Court never went for that, you know.
And you referenced the term contract, and the Supreme Court in Holmgren outlines the fact that this is a contract.
Yeah, it's a court order too, right?
I think it's a combination.
Isn't that the question? Did they violate the court order? And that's the same question as a contempt order, and they said in Burchell, clear and convincing evidence. You guys will have some work to do if this issue actually gets addressed.
Agreed. But I think at this point, it's not this court that, unfortunately, has the power to address it.
Understood. Thank you both for very well briefed and argued. Unless you have anything further?
I do not. The Commonwealth will rest on its brief with respect to the other issues. Thank you very much. Your Honors, I don't mean to interrupt, but one of my pens exploded. I just want to be able to clean it up before someone else comes over here.
Thank you.
You have this on hand. Yep.
We all set? Third case is Commonwealth against KOVAL. 23P 1252. Ms. Hill?
May it please the court, Kathleen Hill for the defendant, MALIK KOVAL. This case is a challenge on the insufficiency of the evidence. The judge's ruling with regards to various counts. Notably, the arguments that we have set forth first and foremost would be on the armed assault and battery with intent to murder. It's our position that there was insufficient evidence to find on that particular count, and that's because there was no malice. So malice necessarily exists when the specific intent to kill is proved, and there is no justification, excuse, or mitigation. And where there is justification or excuse, then it's non-criminal. So
It strikes me that you may be making two arguments here, and I'm struggling to make sure I've got them. There's some things in the brief that suggest that you're saying there was insufficient evidence that he had the specific intent to kill, if you will, which I equate with malice, and I might be wrong about that, and I'm sure my brethren will correct me. And there's another piece of the brief which seems to be saying that the Commonwealth did not overcome his self-defense. In other words, they did not show beyond a reasonable doubt that he did not reasonably act in self-defense.
yes, Your Honor.
Making both arguments?
I think, yes, well, basically, no, I don't see it as that. I think we raised two affirmative defenses, both below and on appeal. And that's with regards to self-defense and the castle rule, which are woven together, and then lack of criminal responsibility. So that was the general focus of the arguments. And so where the justification of the self-defense actually comes from the actions of what happened. It's very fact intense, I think, as you know, as you recall. And so as we started out, Officer DeMiranda was called for a public disturbance. There was a 911 call where there was some trash.
Yeah, I'm going to stop you. It may be that you're saying these are all too interrelated, but now there are three arguments that might go because lack of criminal responsibility is a third. Which are they separate? Which one should I focus on now? Which one do you want to focus on?
Well, I mean, I think, as with trial attorney, what's unusual is both were equally important. It's just an unusual circumstance,
What do you want to
self-defense and
focus
lack
on
of
as
criminal.
to insufficiency?
Lack
though?
of criminal, well, the insufficiency was established with regards to both. And I suppose the.
So can I jump in and try to just, I, like Justice Englander, I'm sort of trying to find my footing here so that I can consider your arguments in a thoughtful way, and it would help me to establish what you're not arguing about. I didn't see that you were arguing that the client didn't know that these were police officers. So that element is not in play. Am I right about that?
Oh, correct, that wasn't.
And I don't see you arguing either that the evidence was insufficient with respect to Officer DeMiranda's injuries, that your client shot, I'm not using assault with intent to murder, assault with intent to kill, just shot Officer DeMiranda. Am I right about that?
Well, he was shot, but there was, it was in self-defense.
Okay, but I'm trying to figure out
Yes.
what we're not arguing about.
Right.
And with
Can I just
respect
pick
to-
up just 1 second on it? Because I saw the word accidental sort of thrown in there, but you're not suggesting that this was, that this could have been accident,
No,
as opposed to absence of justification, mitigation, or excuse?
no, and we
Okay.
didn't. And
Sorry to interrupt, so.
No, no worries. And then,
right.
so
Word was in there.
with respect to the shooting of Officer Moore, I think you are arguing that there was a possible view of the evidence that actually Officer Moore was shot by Officer DeMiranda and not by your client. Am I reading that
Yes, that was the
correctly?
third claim,
Okay.
which was also raised at the motion for required of...
So with respect to your argument about the insufficiency of the evidence with respect to the claims that had to do with Officer DeMiranda, you're arguing, one, that, and maybe the order of these is wrong, but one, that your client lacked the mental capacity because of his mental illness.
To appreciate the
To appreciate.
conduct. Yes.
Okay, and two, that he acted in self-defense / castle rule.
Yes, yes.
Okay.
An unfortunate...
Can I ask you about that
Yes.
first one?
Yes, Your Honor.
So the only evidence that raised the lack of criminal responsibility were the reports that the judge read. Is that correct? And his behavior, and your client's behavior.
Well, yes, and
Bizarre
and
behavior,
the
too.
testimony of various witnesses. I
Right,
mean, there
okay, but was there anything in there, there was no opinion that, because under McCool, it's two parts. Number one, you have to be suffering from a mental illness.
Yes.
And number two, you have to either not be able to appreciate the wrongfulness of your conduct or not be able to comport your behavior, right, to the law. There was no opinion anywhere from the mental health professionals that your client could not either understand the wrongfulness of his behavior or comport his behavior. Is that fair?
Well, I think there was.
Simply saying bipolar and undiagnosed mental illness that's the next step that's required there, it seems to me.
I think there was.
So where was
And
that?
I think the reports do state it. I think the first two reports, if you look at Brigham and Women's Hospital, the psychiatric examination, there was an undiagnosed psychiatric disorder. There was hospitalization twice prior to this event. And then when they...
But where, okay, just point to me where on the record it says not able to appreciate the wrongfulness of his behavior, because there are plenty of folks who have psychiatric disorders who don't reach that next and important requirement.
Right. Well, I think it's a combination of the facts taken together with the Gaudreau instruction. What you're going to take when you're looking for lack of criminal responsibility, yes, you can take into consideration experts' reports, but you can also take into consideration his statements as well as the statements from the other individuals.
Can we just stop for a moment then? Because, okay, first of all, this was raised as an affirmative defense?
Yes.
Properly raised?
Yes.
Okay. And the report that was admitted into evidence by stipulation of the parties is a conclusion of the judge that he did not lack the capacity, did not lack mental capacity to stand for trial, right? That was actually admitted into evidence.
Yes, with regards to that, yes.
Okay.
Yes.
So your argument has got to be that no reasonable jury could find that he had been shown to have the capacity to appreciate whether his conduct was wrongful or not, and to conform his conduct to the requirements of the law, right? That's your position. Based on that evidence, no reasonable jury could find. But you got a report from an expert who opines as to and has stipulated in that he had the ability to stand trial. He was sufficiently competent for that.
Well, I think at the time that was a preliminary examination, and he didn't specifically address with regards to lack of criminal responsibility. At the time in which that was done, it was a lower standard. It was a preponderance of the evidence. The Commonwealth didn't even see the report at the time in which this issue was raised. If I could just, I'm sorry,
Okay.
you trickle. And so it was a finding at that time. Specifically, the judge said at that time it was not an issue. And that was a year and a half before things progressed. This trial came to,
But you didn't have an expert testify there was no expert opinion that said, at the time of the events, he met the McCool factors, right? There was no expert
No, it
testimony to
doesn't.
that.
But what the expert did opine is, he said, it's substantially likely that this untreated mental illness impaired his perceptions, judgments, decisions at the time of the alleged criminal conduct. And so you have other evidence that you could have relied on as well, too. You have all the witnesses that were testifying about his conduct.
I understand. Hang on. I just want to make sure. The expert, did he testify, or was it just a report that was
It's in
stipulated?
his report, and the
So it was a
stipulation
report
was
that was
there.
stipulated into evidence?
But I think that the case that that I'm relying on is Commonwealth versus Lawson, in which there no longer is a presumption of sanity. The burden shifts as soon to the Commonwealth as soon as there's a suggestion of a lack of criminal responsibility. And so when these reports came in, they agreed to stipulate, well, you know, they did it at their own risk by not
So why isn't it
challenging.
just then a fact finding by the judge who could look at, well, he said in a statement shortly thereafter, I wouldn't have shot you because you're a good guy, but I shot them because I was angry.
No, I don't, there's
I
no
mean, I'm paraphrasing.
I don't think there's no testimony that he was angry. I think that's what the Commonwealth says in its brief.
Okay.
But only the witnesses
So
say,
let's
two
just stick
witnesses
with,
say he was
to the detective that I
agitated.
know that was my school resource officer, you're one of the good guys, so I wouldn't have shot you.
Well, you
So
know,
doesn't that seem to suggest that, A, he could comport his behavior if he chose to, and/or that he appreciated that what he did was wrong?
No, I don't think so. I think if you take a look at the testimony, when you look at Detective Lowen, when you're talking about it, he actually references, he says on page 222 to 23, he had become lucid. He recognized me. Detective Lowen knew him for years previously, and so I think that statement right there suggests that he was aware that he was having difficulties. He's aware that he has a mental illness. He was aware that he wasn't lucid at that time.
But all of this evidence is evidence that was presented to the trial court. And to go back to Justice Englander's framing question, in order to win, you can't, it is not enough to say that the trier of fact could have looked at this evidence and done something different. You need to prove that no reasonable jury could look at this evidence and conclude that your client was able to tell the difference between right and wrong in that moment. And when the best you have is he had not been lucid, and then he kind of came back into himself, and expert reports saying that he suffered from an undiagnosed mental illness, and nothing saying he was, that he meets that factor, that he was unable to distinguish between right and wrong, unable to conform his behavior. What is it in this evidence that means that no reasonable jury could have concluded what the trial judge sitting as jury concluded in this case?
Because I think the burden shifted to the Commonwealth, and the Commonwealth didn't prove its burden.
I don't think that Lawson says what you think it says. I read Lawson as saying that the Commonwealth can rely, and now I'm quoting, on the circumstances of the offense and all that the defendant did and said before, during, and after the offense to prove the defendant's criminal responsibility. It doesn't say the Commonwealth has an affirmative obligation to come forward with experts.
It shifts, and if they choose not to challenge the evidence that's presented, which there's a wealth of evidence of the individuals saying, even Officer D. Miranda says he's not rational. He's talking to him at the inception, and that's consistent with the other witnesses that testified. I think from the witnesses' testimony and statements, I don't think any reasonable person could have found that he was rational, that he was lucid at the time of these events.
The thing is, rational and lucid are not the test. You can be suffering from a mental illness, even a serious mental illness, and have the capacity and not lack the capacity to make choices that conform your behavior to the law.
Well, I think when you take a look at his frame of mind, the actual statements that he was quoted having said to various individuals, is that he was afraid of police officers and that they were going to kill him.
How about when he said, I got mad when I saw my mother get tossed to the ground, and that's when I did it. I ran into the house, grabbed the gun, and I shot them. I mean,
He said
Yep.
I believe he
I
said
got mad when I saw my mother get tossed to the ground, and that's when I did it. I ran into the house, grabbed the gun, and I shot them.
And
That's in the immediate aftermath, within an hour, I mean, not short, very short time when he's sitting down with the
that's
detective.
after he's lucid. That's what he's saying
Okay.
to Detective Lowen.
Okay.
At that time. So that's why I say there was nothing to support that he was lucid. There was ample information in the reports talking about a history of mental illness and paranoia that influenced his reactions of what he could do.
I'm going to, your time is up, and I have a couple other questions. On the issue of self-defense, it's your position that the force that he chose to use was reasonable under the circumstances?
Given the circumstances, yes, due to the Castle rule, that he was...
How does the Castle rule help him? The Castle rule only says he doesn't have to retreat. It doesn't say that he can use unreasonable force.
Well, that's not unreasonable force if you...
Right? I mean, the
If you
question is
consider-
reasonable force. He can pull a gun on somebody who has not pulled a gun, who simply pursued him into the house.
I
That's
think-
your position.
I think, well, if you look
It
at
is
self-defense...
reasonable force to shoot someone
He
who
didn't-
has not pulled a gun, and the most they have done to you is chase you around the front yard, sounds like a Keystone Cops kind of thing, and then put their arms around you from behind. Is that the position of the defense?
No, that's not the position of how it transpired. It's
What did I get wrong?
There was unnecessary and excessive force by the police officers. And what also made
What
this...
was the unnecessary and excessive force? Reaching out to grab him?
Well, yes, if you go back to, like I was trying to get to the setting of Officer DeMiranda, he had everything under control. He was doing a preliminary investigation. When Mr. KOVAL came out, he had him do a 360 turn to make sure he didn't have any weapons. Officer DeMiranda testified that he felt comfortable and that he did not see a crime here. It wasn't until Officer
But what is the
Moore...
unreasonable force?
The
Help me
unreasonable
with that.
force is when Officer Moore steps in and he takes a bladed stance behind Mr. KOVAL.
Well,
And he
that's not
says-
force at
and he-
all.
and he-
That's a stance.
I'm leading into it. I think it's an accumulation of things. It's a chain that's connected, what's been done. What makes this case rare and unusual from everything else is, remember, Officer DeMiranda and Officer Moore never gave any directives, never said you're under arrest, never said stand, do this, do that, or whatever. They just set into motion at a very
Okay.
fast...
Being shot at.
Well, they weren't shot at the inception when they were outside. Everything was under control until Officer Moore came up and attempted to grab him without saying any words, nothing. And Mr. KOVAL said, why? Why? Still, he didn't answer. And then he continued to go behind him and to try to grab his shirt. And
Okay,
there's-
I think we've got the facts, and your time is up, unless there's other specific questions.
Right.
All right, thank you very much.
Good morning. May it please the court. Rosellen L. Corey for the Commonwealth. Before I get into any argument, I do want to acknowledge Chief of Appeals for the Cape and Islands District, Elizabeth Sweeney, who worked very hard on this appeal, including while she was out of the office on leave. So I did want to acknowledge her work on this case. Resistance to arrest, even an illegal arrest, would frequently result in far greater consequences for the officers and the occupant of a home than the unlawful intrusion of law enforcement onto the defendant's property or the illegal arrest. That's paraphrasing, but that is from the decision Gomes from this court, 59, Mass Appeals Court 332, page 343, a 2003 decision. Over 20 years ago, this court stated that resistance to an arrest, even an illegal arrest, can culminate in circumstances far worse than just the unjustified intrusion onto personal liberty.
But there was no arrest here, none. They never said you're under arrest. They never, ever, they didn't have a basis for an arrest.
No.
Or was the intrusion into the house, following him into the house, was that lawful?
At that point, there was grounds for an arrest. At that,
Which is what?
the push on Officer Moore to take him to the ground when they were
So Officer
around.
Moore had no basis to reach out and grab him,
He
right?
testified that he observed the defendant's agitation escalating, and he was concerned for safety not just of Officer DiMarino, but also of the
So the Commonwealth's
civilians who were
position
nearby.
is, you go to talk to somebody on the front lawn who's reportedly engaged in breaking glass in the street, and because of the agitation they show, you can grab them and pat frisk them?
The Commonwealth's position is that when an officer makes an assessment that there is a risk of agitation displayed by an individual escalating into a threat to officers and passerby, then there is reason to
Did Moore
place that person-
testify that he considered him to be a threat when he reached out?
I don't remember off the top of my head if he used the word threat.
I didn't see that.
I do remember him stating that based on his observations, he was becoming concerned, which is why he moved behind the defendant. And then as the defendant's agitation increased, that's when he did make a move to restrain the defendant.
Your position is that was lawful?
My position is that when an officer makes that assessment, even if the officer is incorrect, the level of resistance that the defendant ultimately displayed is not appropriate. It does not justify.
You familiar with the case that just came out from this court on that subject?
It's, is there a specific
I
case?
think it's
Your
called
Honors?
Tyson.
Sorry?
I think it's called Tyson.
I can't say off
Yeah,
the
it
top.
is. Commonwealth against Tyson.
I can't say off the top of my head.
It's almost directly on point in terms of what you may do with resisting actions by a police officer, short of arrest. Okay.
Can I ask you a narrower question?
Sure.
On the 10A violation?
Yes.
How's that not part of the curtilage? When he stumbles out having been shot onto his lawn and drops the gun 3 steps, 4 steps out of the house?
The Commonwealth's argument on that point would be that this is a fact-specific inquiry, and that based on the findings of the fact finder, that that was.
Right, and the question is whether any rational finder of fact could conclude that.
I want to understand what the argument is.
I would agree that that is the standard.
He can't be convicted unless he's outside his home, right?
Correct.
And he was, the only time the gun was outside his home was when he fell down the steps.
I think he walked down the steps and then
Because he'd been
fell
shot
a
6
little bit.
times.
Yes, he had been shot multiple times after shooting the officers.
Yeah. No one's, I don't think, I'm not going to speak for Justice England, I don't think anybody's justifying shooting the officers or suggesting it was wrong. The question is, if he's convicted of possession of a firearm not while in his home or place of business and leave place of business out, how is he not at his home at that point? And I get that you can't take a gun from the inside and port it outside, but I think you got to at least have a toe on the sidewalk.
Again, it's a very fact-specific inquiry.
Okay.
He's convicted of possession without an FID card, that's fine, right?
Yes.
But the possession without license to carry requires it be outside his home.
It does.
Okay. Can we talk a little bit about what the facts are with respect to the defense of lack of criminal responsibility?
Sure.
What would be, so do you have the burden? She's citing Lawson. I think I've read it at some point in my life. The Commonwealth had the burden here to prove beyond a reasonable doubt that he had the capacity.
So at the outset, my position would be that I don't think the defendant's ability to be criminally responsible was as live an issue as it has been painted on appeal. If you look at even the initial argument in the motion for a required finding of not guilty, I believe, page 53 of volume 3 of the transcript, defense counsel is arguing mens rea. He's not arguing that his client didn't have the capacity to form, or make the necessary
Did they
judgments.
raise the issue? I mean, there has to be notice under one of the rules, right? Rule 14 or something? You have to say, hey, I'm raising the defense of lack of criminal responsibility.
I believe there does have to be notice. I don't believe there was notice in this case.
He did put it in his supplemental request for instructions,
Yeah.
but that's about
Yes.
it. Seems to me on the record here. That was about the only time I saw it pop up is in the jury or judge self-instruction request, if you will.
Right. And
And your position is that it was not either factually or in fact raised. Is that both of those things?
I would argue that it was not raised as one of the arguments that defense relied upon in presenting the defense of the defendant.
Geez, that's a lot of words. So this is the way I think it should work. And you correct me if I'm wrong, and then help me fit it into the framework of your case. I think they need to tell you that they're raising that defense, because that tells the Commonwealth, maybe I need to get an expert. And if they don't tell you that, then I think that's a real problem for the defense, because they haven't put the Commonwealth on notice that they might need an expert witness. And sort of saying, at the end of all the evidence, oh, I raised enough to show a lack of criminal responsibility, so now I want you to instruct on it, Judge, doesn't seem right to me as a matter of procedure.
The position I would take is that it would, as an attorney for the Commonwealth who does a lot of appeals, I would always prefer that a fact finder be over-instructed rather than under-instructed. If there's a chance that this could be grounds that the fact finder could find was sufficient, even if it wasn't properly raised so that the Commonwealth had an adequate opportunity to respond, I would prefer that the fact finder be instructed in that way, so that they can reach a conclusion, as the judge did in this case, that conviction on these charges was appropriate.
Then you have the problem that you actually had to have evidence from which you would prove beyond a reasonable doubt that he had capacity. Don't you have the burden? If, under Lawson, if the issue is properly raised and in the case, then the burden shifts to the Commonwealth to prove it beyond a reasonable doubt.
Yes, and I would agree with Your Honor that it wasn't properly raised.
Okay, so let's leave that aside, because I just heard you arguing something else. So
Well,
now,
it's-
what is your evidence? If
So-
we get to that, what is your evidence that he had capacity?
Even beginning with, I guess not beginning, it was on the second day of trial, one of the, I believe he was a son of the neighbors, Mr. Letico, testified that he had a conversation with the defendant before police showed up. The defendant stated that he would be ready when they came for him, and that's on page 68 of volume 2 of the transcript. And he also, that same witness testified that the defendant seemed angry at that time. Then moving to the testimony of...
So that statement, if they come, I'll be ready for them, that was made after the police had been called, right?
I don't recall if it was
was
before or
this-
after the police had called. It was definitely before the police had arrived, though.
It was before the police had arrived, but like in that same time frame, within minutes of the police arrival.
In that span of the afternoon,
Okay.
yes. So from the outset, this defendant had a mindset about how he would respond to police action or arrival. Even in his initial conversations with Officer DeMiranda, when Officer DeMiranda identified as a black man, he told him, "You're working with the cops." And that's on page 72 of the first transcript. Then again...
But why aren't those statements equally representative of mental illness as of sanity?
I think because once you get to the statements that the defendant makes after this has all occurred, that he was angry when he saw not any interaction with himself. It was when his mother was pushed to the ground. That's when he says, "I got angry, I went inside, I got the gun, and I shot them." And he admits, he says to Detective Lowen, "You are one of the good ones. I wouldn't have shot you." There are statements there that make clear that there was intent. Any level of confusion about a threat doesn't match the defendant's statements or his actions. Officer DiMiranda even testified when he ran in after the defendant, he was concerned, he wanted to restore peace. He wanted to make sure the defendant wasn't grabbing a weapon. He said, "I saw him going into the kitchen, and I know that there are knives in there." That's what he was expecting. He wasn't expecting a gun. He wasn't expecting to be shot. The defendant's decision to break from Officer Moore, he pushes Officer Moore to the ground to gain separation, run into the house, grab the gun, and begin shooting the minute Officer DiMiranda, wraps him, trying to...
Position is the pushing of Moore is sufficient to give you probable cause on an assault and battery?
On straight assault and battery on a police officer, yes, it is legally sufficient for that charge.
Moore is chasing him.
Yes.
Arguably without cause around the front yard, and the guy drops to his knees and tackles him.
Yes.
Right? Is there a question there whether that's reasonable self-defense as a matter of law? Police officer, I guess that gets back to the Tyson case. Okay.
I would say if there were actions that were taken that would be closer to reasonable, it would be the unarmed actions of the defendant.
Okay.
If there are no further questions.
Just briefly on the yeah, I think I get it. Your position is right that it was the testimony that he was looking toward Miranda when he got shot in the back of the head more, that at least if a fact finder accepted that was sufficient, regardless of all the other.
I'm happy to walk through it too, and I did make a note.
A lot of confusing ballistics evidence.
I believe it was page 54 of volume 3 of the transcript where the judge does say he credits the test, or if he were to credit the testimony about the sequence of events and positioning, then that would be sufficient to move past the motion for required finding of not guilty. But essentially, just to run through it quickly,
Right.
The defendant enters into the house and turns right towards the kitchen. Officer DiMiranda enters the house, turns right towards the kitchen. Wraps him in a bear hug. Officer Miranda feels himself being shot, turns now running left away from the defendant. He doesn't run out the door. He instead runs basically out of line of sight on a staircase. At that point, Officer Moore, who has heard the shots, has come to the doorway. He doesn't go really past the doorway. He's turned to the right. He sees Officer DiMiranda run past him to the left. He says, "Since I was already going that way, that's the way I turned to head back outside since there was shooting." And he said, "Before I got outside, I felt the impact to my head." And then Officer DiMiranda did testify that he took a moment on the stairs to collect himself and to respond to the situation. He said he saw the defendant coming with the gun in his hand. He said he saw no one else. He said
Never sees Moore.
Yeah, he said he didn't see anyone else in the doorway. And that is when he began shooting. So,
Okay. Thank you very much. Thanks to both of you. We're going to take a 15-minute break. We have 2 more cases to be heard. We'll be back shortly.
Court is in session. Please be seated.
Okay, the next case is John BEAUDOIN against ROHIT BHASIN and others, 23P 1464. I apologize if I pronounced that incorrectly. Mr. BEAUDOIN.
Good morning, Justice Englander, Justice Hershfang, Justice Brennan. May it please the Court, I'm John BEAUDOIN Sr., acting pro se. I'm not a lawyer, I'm just an engineer. The defense is going to try to convince you the case is about vaccine and religious exemptions and medical exemptions. It worked in the lower court. The court was confused, and I'll review that here momentarily. The court conflated two separate fact patterns as well, one that happened in 2020, which is an email exchange with the Director of Admissions and myself for admission to the Massachusetts School of Law. And the second, the second fact pattern is associated with a religious exemption held out on their website for the students in 2021 for the COVID vaccine. So first, this is about whether the sufficient facts were pled in the complaint to confer standing. I mean, that's why we're here. The complaint was dismissed on standing. There are two issues I'll go through. One is a general standing. The other was a 93A complaint.
I don't think the judge actually, and I appreciate you've had 1 year of law school. I appreciate the briefing. I think the word standing doesn't help us. That's not what the court really was focused on, and it's a legal concept that, to my eye, has no relevance to this particular case. I mean, really, there are two issues. One is, did you plead sufficiently based on the communications that you'd had with the school to raise breach of contract and related claims, and did you plead sufficiently to plead a 93A claim? And why don't you take them sort of in those chunks, if you will, whichever one you want to go with first. If you want to start by talking about the contract case, please do.
Sure. So with regard to all the different contract theories that I pled, and I pled promissory estoppel, covenant of good faith, and all five different ones, the court focused on the email, which is really at the crux of this whole case. And the email in question had four different sentences in it. The court chose the third one. I'll just read the email because everything is going to flow from that. If you are over 30 years of age, you are not required to show proof of immunizations or vaccinations to the law school, period. No one at the law school will ask you to provide proof of a flu shot or COVID shot, period. If your doctor thinks it is not advisable to get the COVID vaccine, then we will not require it, period. And the last line, trust me, no one will be the first one running to get the vaccine when it's available. I'm with you there.
And the date on that is what, 2020, when? When in 2020?
It was August 2020.
August 10th?
8/10/20, yep.
Okay. I mean, actually, you got to start before that, right, with your email. You get from them a contract,
Yes.
essentially, a document that they ask you to sign. I forget the exact name of it, but basically, here are some rules that we want our students to abide by, one of which is that you agree to get vaccinated, both for a flu shot and a COVID shot, if appropriate, I think is the words they use. And you respond by saying, can't agree to that, or words to that effect, right?
Yes, I basically said I'm deaf in 1 year since I was 4 years old from getting a shot.
Leave that aside. How do you start that email? I don't have it right in front of me at the moment.
May I? This is from page 12 of your appendix, which is paragraph 26 of the complaint. Hi, Rohit, and I may be pronouncing that wrong. I apologize. I just came across the line that states I'll get a flu vaccine and a COVID vaccine when available, period. I cannot commit to that, period.
Yes. So I made it very clear I wasn't going to get the vaccine. If I might go back even further, there's another, if you look at Record Appendix page 85, and a friend of mine just pointed this out to me an hour ago. I never found this, but on the last line of page 85 of the Record Appendix, P.S., if you are over 30, you do not have to provide proof of immunization.
Where's that from, though?
That was from an earlier email from ROHIT. I just found out an hour ago. It's actually in the record appendix as originally.
It's not in the complaint. Was it attached to the complaint?
Yeah, it was attached in exhibit, probably on page 55, I believe.
It's Exhibit B.
And why was that a PS? What were you talking about?
Well, he was just sending me information and said, in the end, I told him, I'm deaf in one ear. I think I told him verbally at that point. He said I don't have to get it. And the reason I raise it now is because in the decision and order from the lower court, they selected that third line, and they said specifically that line conditions the prior to. And it doesn't, in my mind. And that decision, whether or not it conditions the other two, is a fact in the purview of the finders of fact, the jury.
So is it your position, sir, that this series of emails committed the law school to never requiring you to be vaccinated or provide proof of vaccination under any circumstances, regardless of the evolution of the illness or the pandemic, I should say, and or the availability and efficacy of vaccines without some exemption?
Yeah, I am contending that. It's an express written statement, and I would not have gone to the school otherwise. It's a fraudulent inducement. He could have very easily walked right next door to the next office and asked the dean, but he didn't do that.
So,
I'm sorry, go ahead.
No, I don't want to interrupt.
No, I'm good.
Can we talk then a little bit about the references to the sort of the second piece of your contract-based claims has to do with a year later.
Speak up.
A year later.
Thank you.
You're told, we're not going to let you on the campus unless you provide proof of vaccination, right? And you then go through a process of seeking an exemption, and how are you made aware that the exemption is available?
The exemption process was listed on the website. Other students told me about it, so I filled out the exemption. They said I had to have it notarized. I got it notarized. I went through the process, and they just...
I'm sorry, but is the... What was on that website, the information, I'm sorry, I understand now. The information that you used to determine that you were going to seek an exemption, is that in the record? Is that attached to your complaint? And do we know exactly what was said by the institution to you regarding exemptions?
All of the written communication is in the record. It's in the original exhibit from the complaint. The phone calls, I don't have a log of the phone calls. I did call up and say, when is he going to rule on the exemption? Oh, he's on vacation.
But backing up simply so one of the things that's on my mind is, okay, well, it's a contract case, right? What representation was made to you regarding the availability of exemptions? That's what's on my mind right now. Is it in the record so that we can take a look at it? Is it in the complaint? Was it attached to the complaint?
Yes, the exemption process is there. The exemption was notarized. It's in the record. I filled it out. It was notarized. I submitted it.
Did they make a representation that here are the standards under which, was there anything that said, look, here are the standards that we're going to use to determine whether you get a medical exemption or a religious exemption so that we know what the contract was?
It was clearly a form that had been used out in the public sphere with regard to exemptions. So yeah, there were standards within it. I did cross out a line when I submitted it because I wouldn't commit to one of the lines. I didn't just blankly sign it. If they didn't want me in the school, that's fine. Tell me. Okay, the violation, they didn't promise a religious exemption. They only promised a process. They didn't follow through with the process. They unenrolled me from the school before registration even ended. I got a letter saying I was unenrolled. That's after they stopped communicating with me entirely. They didn't want to talk to me. I would like to know if they ruled on anybody's exemptions. That would be really nice to know. They didn't rule on mine.
I'm sorry to interrupt. I think you alleged in your complaint that you started hearing from other students that they had gotten rulings.
I did, but being hearsay, I didn't want to bring it up now. So
Well,
that's what prompted me to to call them up and say, hey, what's going on? And they wouldn't return, so then I sent an email. I did get an email earlier saying, we tried to contact the deacon. I'm like, and they started arguing fetal cells and stuff with the deacon. And I'm like, he's just a friend. We go to Bible study together. I don't claim that I'm Catholic. I claim that I'm Christian.
Did they not tell you, Mr. Bowden? Sorry, Bowden, that, is it Bedoin, Bowden, how do you say it?
Baudouin.
Baudouin, neither, or nor. Did they not tell you that in order for them to continue to process, they needed a reply from your friend, pastor, whomever, however you want to characterize it?
Yeah, but I had to seek that answer from them, and that interaction should be in the record. They did say that I needed that. I replied to them saying, he doesn't determine my religious beliefs. He's just there to say that I have religious beliefs, and he knows it because, not because he's a deacon in the Catholic Church, but because he's a friend with whom I attend Bible study. So he knows that I have a faith.
Okay.
And really, you know, I didn't want this to go down the path of talking about the religious exemptions and whether or not, you know, it was promised. It was not promised. The process was promised, and the process never happened. They unenrolled me from the school before they ever ruled on it, after refusing to communicate with me. And the last time I communicated with them during August of 2021 was to say, hey, you know, registration ends for next semester. I haven't heard from you. What's going on?
So and with it, go ahead. I want to be 100% sure that I'm following your argument. And also, if I'm too quiet, just raise your hand and I'll yell louder. We had spoken when we first started talking here today about a sentence in the second sentence in that email that said you will never be asked to provide proof of vaccination.
Correct.
But if I understand you now, and from reading your brief, it seems that the argument you're making to us doesn't have to do with that sentence. It has to do with the process, or in your view, the lack of process around. Okay.
No, I'll explain.
Correct.
And again, these are two different fact patterns that are being conflated. One is the email in August of 2020, and the other is the exemption process. The email from 2020 was from Defendant BHASIN, who is the Director of Admissions, who made call it a peril statement, but it comes in because it's fraudulent inducement. So that happened in August of 2020. That formed a contract term, and that is why I matriculated. Secondly, Defendant Coyne, being a dean of the school and the school itself, and the school is also responsible for BHASIN's statement, but the school and Defendant Coyne are responsible for extending the process of the vaccine.
But it's two different arguments.
They're two different arguments.
It's two different arguments
Yes.
and two different allegations.
Yes.
There's a contract provision here, there was another contract here.
Correct.
And those were both violated.
Correct.
Okay. Do you want to address, unless you have more?
I'm good.
Do you want to address your 93A argument at all?
Yeah, I got 2 minutes, so I can do that rather quickly. The 93A really hinges on whether fraudulent inducement is in furtherance of the core mission of the school. The carve-out.
You don't allege fraud.
I'm sorry?
You don't allege fraud.
Okay, the negligent misrepresentation.
It's a big difference.
Yeah, I get it.
Okay.
There's an intent aspect with regard to reckless
Exactly. You have to be, for fraud, you have to allege when they said it, they didn't believe it. They did not intend to do it. You have not alleged that, and understandably, and, okay.
Okay, so it being negligent misrepresentation then, that vitiates the carve-out for whether it being in the furtherance of the core mission of the school.
Okay.
In fact, there is a line in Squirry, the Squirry Court, no, the Squirry Court, no, this is, the Squirry Court thus found recruitment practices to be at least incidental. That's not the one. Here we go. From linkage, sorry, I got the wrong case. An entity's status as charitable corporation is not dispositive of the issue of whether 93A applies. It's not just about whether or not they're a...
But it often is dispositive under the case law, right?
Yeah, it often is, but when there's an inducement such as they made, then it should be in. I mean, that is the carve-out they're going after by stating this.
Okay. I mean, there's one case that I'm aware of that's allowed a 93A claim to go forward against an educational institution. That's linkage, and it had radically different facts than these, right?
Yes, however, the fact of whether or not it's a nonprofit organization is still up in the air to me. I mean, if you look at
Well, I mean, it is a nonprofit organization. I think your argument is that it shouldn't be, which is a
Correct.
fair argument that you can make, but it is a registered 501c3.
It's registered as one. Whether or not they're acting as one in their core mission is a different case. And that I plan to prove based on their bar passage rates, for one.
Can I take just an extra moment to ask about, you've sued both of the individuals in their individual capacity, and I want to make sure I understand the basis for those claims. I think that I understand with respect to Mr. BHASIN that it has to do with what you say is the fraudulent email from August 10th of 2020. Anything else for him?
Well, for both the individuals, they're not nonprofit entities. And
I'm sorry, say that again, please.
I'm sorry?
Just didn't hear what you said. They're not.
Oh, they're not nonprofit entities in and of themselves. So the case was dismissed for all defendants on all counts. And it
But-
should not have been dismissed against them.
I'm asking kind of a different question, which is what are the things that they individually did that make you claim that they are liable not only, as individuals? So
BHASIN's statement, his employment, people's employment is generally based on performance. Okay, if you don't do your job, you're either fired, but in some cases in sales and so forth, if you do your job well, you get extra money in variable compensation. Now, I don't know, and I'm not, speculating, I'm just saying as an example, in most businesses, if he were to get variable compensation for getting more people in, then he had a reason for telling me, hey, you're over 30, don't worry, come on in, and taking $28,000 in a year of my life and then ghosting me and not talking to me after.
So that's his motive, in your view. How about Coyne?
The interaction with Professor Coyne, Dean Coyne, who was my professor for civil procedure, by the way, there was a case that I was involved in, I was talking to him about, and I know that he has an opinion of me that I guess, I don't know how to say it here, so I can't answer your question other than to say, as an individual, he's responsible for holding out those religious exemptions. He is the dean of the school, he's responsible, and they said that he's going to rule on him, he's going to rule on him, he's going to rule on him, and he never ruled on it. So he's personally responsible for not ruling on it. I guess that would be where I get him in.
Okay.
He did not follow through on the contract to.
Your time is up at this point.
Thank you very much.
Appreciate your presentation.
Thank you.
And this is Mr. Malagudi?
Yes, Justice
Did I
England.
get that right?
You did.
Okay.
Good morning, Your Honors. May it please the Court, I am Peter Malagudi, and I represent the appellees in the case, ROHIT BHASIN, Michael L. Coyne in the Massachusetts School of Law. Your Honor, we are not here to talk about vaccines or COVID. We're here to talk about the 7 causes of action that the judge deemed insufficient to withstand a motion to dismiss down at the Superior Court. The Court seemed most interested in addressing first the question of contract, so I think I'll start there. I think, Justice Englander, you captured it correctly. There seem to be 2 arguments about 2 separate contracts that are involved here. The first
Or 2
was
separate provisions, maybe, or additions to, or however you want to frame them.
well,
Obligations as a result of his being a student at the university.
sure. So the August 10th, well, I'll take them in chronological order. The August 10th situation was the correspondence with Mr. BHASIN. I think it's important here to understand, where we were in the pandemic at this time. On August 10th, there were no vaccines at this point. And Mr. BEAUDOIN starts out the conversation, sends an email to Mr. BHASIN, saying to him, look, I can't take the COVID vaccine. If it comes, I can't take the COVID vaccine. Now, if you look at Mr. BHASIN's reply closely, he starts by talking generally about what the school's practices had been for other vaccines, you know, the flu, the measles, those types of things, and says if you're over 30, you're not going to have to take those vaccines. He then specifically...
That's not what it says.
Yeah.
I'm sorry. I think you have an extremely difficult argument here, okay? Others on this panel may disagree with me, but it doesn't talk about past history or other vaccines. It says, he says, I just came across a line that states that I'll get a flu vaccine and a COVID vaccine when available. I cannot commit to that. Can I get an exemption from the vaccine requirement? And the response is, if you are over 30 years of age, you are not required to show proof of immunizations or vaccinations to the law school. No one at the law school will ask you to provide proof of a flu shot or a COVID-19 shot. Now, based on that, why wasn't it reasonable for him to believe that if he went to school, at your school, that he wasn't going to have to show proof that he'd been vaccinated for COVID-19?
Because, Justice Englander, that was not the entire statement. The following sentence modified that and said, if your doctor thinks it is not advisable to get the COVID vaccine, then we will not require it. It distinctly put a condition on the COVID vaccine.
No, it didn't. It at most is inconsistent with the prior two statements, at most. And isn't that a jury question?
Well, Your Honor, when it comes to construction of contracts, it's a question of law, and respectfully, it's a judge decision in Massachusetts. And this entire argument
It's a judge decision, but if it's ambiguous, we take parole evidence, right?
Your Honor, I submit to you that there's nothing ambiguous in the phrase, if your doctor thinks it's not advisable to get a COVID vaccine, then we will not require it.
Yeah, but there's also nothing ambiguous in the phrase, no one at the law school will ask you to provide proof of a flu shot or COVID-19 shot.
Yes.
And that's exactly what happened, right? After the vaccine became available, this message went out to the whole community saying, we need proof of a COVID-19 shot.
Well, the message that went out on June 1st, 2021, Your Honor, it went out through a constant comment blast to the students, said that everyone will have to get a vaccine unless you can get an exemption.
Right, and
it
that is...
mentioned two exemptions.
That is requiring proof of a COVID-19 shot unless you get an exemption.
That's correct, Your Honor.
Which is inconsistent with the second sentence. Which is inconsistent with the second sentence.
Well,
you will be required to show that you've been vaccinated when the sentence says no one will require you to show that you will be vaccinated. And we're at the stage of, I understand that you have an argument that a reasonable construction of this is to the contrary. I understand you have that argument, but we're at the stage of whether he's pleaded a claim. Why hasn't he at least pleaded a promissory estoppel claim? You've said something. He relied on it. He says, I relied on it. I wouldn't have gone to the school if you hadn't said it. I went to the school. I spent money. I'm out the money. You owe it to me. I mean, that's, it seems to me, first-year law student promissory estoppel.
Your Honor, respectfully, first of all, this is an email exchange, historically inartful exchanges. Secondly, Your Honor, you know, contract construction...
Excuse me one second. Are you suggesting that because it's an email exchange, which may be historically inartful, that it is not then, it cannot be considered as part of the contract or a separate contract or a modification of the contract in any way?
No, I'm suggesting, Your Honor, that you have to take all the circumstances into account. Now, here is an admissions director, Your Honor, who has nothing to do in the school with healthcare policy. I think that's pretty open and obvious. He is engaged in recruiting Mr. Beaudoin at the time. Mr. Beaudoin, in the end of his prior email on the same day, on August 10th, even recognized this. His final comment was, "To whom can I plead my case?" So he even recognized that he might be coming to the wrong person here.
Yeah, but then the response doesn't say, hey, you need to talk to so-and-so. It says, no one is going to require you. All right, I think we've got it. Let's move on to the other issue, which is whether there is some sort of contract claim arising out of whatever was said about the exemption process. I take it that what has been represented is accurate, that there was something on the website that indicated you could get an exemption.
Yeah, more specifically, Justice Englander, Mr. Beaudoin contacted, after the constant comment email blast that I just mentioned, Mr. Beaudoin contacted the registrar and said, what can I do? I don't want to get a COVID vaccine. And she referred him to the website. And so that's how he got to the website. And the website provided the forms for both a medical exemption as well as a religious exemption.
Do you think that, is there either if I look at this, I'm told it's in the record, if I look at it, is there going to be an express representation that if you apply for an exemption, we're going to rule on it? Or do you, and if there's no express statement to that effect, is that something that should be reasonably implied from the fact that the website offers an exemption process?
I think it's fair to say, Justice Englander, that if you file a complete exemption and you provide the proper documentation that you're supposed to provide, then yes, there will be a ruling on the exemption.
And if you don't, wouldn't you assume that they'd say, hey, your request for an exemption is incomplete and we need this from you?
Well, I think that's exactly what Dean Coyne did when he reached back out to Deacon Tremblay and asked him for further information. Your Honor, the application asks for the religious tenets, essentially, that supported his decision, his religious decision not to take a vaccine. First of all, I don't consider the application a purely religious one. Mr. Beaudoin admits in his brief that there's a medical predicate to his claim. He is saying that...
The difficulty with this is you're arguing facts, and the question right now is whether he's stated a claim. And he says there's an exemption on there's an exemption form. I filled out the form, and you never ruled on the form and on the request. And I take it that that's basically conceded. And with that, I mean, I understand there's a real issue as to whether there will be any damages associated with this, even if it's able to prove, a violation of maybe the obligation to have good faith and fair dealing, for example. But what have I missed about whether or not that's sufficient to state a claim?
That he never completed the form, Your Honor. First, he crosses out part of the form that he doesn't want to agree to. Then he submits a letter from a Catholic deacon which says his beliefs are not those recognized by the Catholic Church, and then he tries to disown the deacon, essentially, and says, no, I'm not really referring to the deacon. So really, there's no support for his claim from a clergy member, as was required in the application. And this was the go-around that Dean Coyne tried to have with Deacon Tremblay.
But then, I guess, to the point, why not then just say denied? That's, I think, his point. If he crossed the form out, submitted a letter that wasn't sufficient, and then despite their best efforts, in your view, to help point him in the right direction, they never actually said, well, this is insufficient, you didn't follow up, it's denied, right?
That's correct, that the words never came back, that was denied. What words came back to Mr. Beaudoin was when he called the registrar and said, why hasn't COIN ruled on my submission? The registrar replied by email that he's waiting for a reply. He sent a letter to Deacon Tremblay, and he's waiting for a reply from that. And he never got the reply from that. He never got the support for the application for the religious exemption. And as Mr.
What he did get was a response from Mr. Beaudoin that said, forget about the deacon. You don't need to hear from him. These are my religious beliefs. That was never responded to.
Which now has him not complying with the requirements of the application. The application.
Do we have in the record, I mean, I've been scrolling through it, I can't find it, but that doesn't mean it's not here. Do we have the requirements of the application? I see the affidavit. Obviously, filling out the affidavit is part of the requirements. But is there anything, to Mr. Beaudoin's point, is there a printout of the website, or is there an articulation from the school of here's how you go about this, here's what we need?
No, Your Honor, not that I know of. What I know is that the application, as Mr. Beaudoin described it, is essentially self-directing. It asks for the information that is needed. And one of the things it asked him about was, did you see a doctor? Even in the religious application, he said yes. He gave the date that he saw the doctor, named him. And then it's provide a letter from a clergy person supporting the claim. And that's where the Deacon Tremblay letter came up.
Well, it also says, in the following space, fully describe what your religious beliefs are and why those beliefs prohibit you from obtaining the required vaccination, which Mr. Beaudoin did. Is there anything that explains whether you need both of those, or what by both of those I mean both your own explanation and a supporting letter from the clergy, or whether one is enough?
The application required a letter from the clergy, Your Honor. And I think to exacerbate the problem, Mr. Beaudoin's explanation was not really based on religious tenets. He said, I have a medical issue that is either going to kill me or permanently harm me, without providing any medical justification to support that. And then he said, my religious belief is that it's against God's will for me to harm myself or maim myself in that way. So even that is not supported, Your Honor. Even his own statement is not supported.
Can I, very briefly, on the 93A, he makes an argument with respect to the individuals, saying, the entity is maybe protected, but the individuals aren't. He doesn't say it quite that way, but that's the way I'm hearing it for now. Are there cases, I assume that we're going to find cases that say that individuals acting as agents of an educational institution are also not liable under 93A? Is there a case you'd point me to?
No, I can't, Your Honor. And I suspect, and I have to be candid with the court, that you might find one or two cases that say that an individual, at least in a closed corporation, a small corporation, I've dealt with cases like that before, can be liable for 93A. I can't direct you to a particular case.
Well, they can be, but then don't they get the cloak of the case law that says educational institutions are not engaged in trade or commerce? So if you're an agent acting for that educational institution in a manner that is not in trade or commerce, you also can't be liable.
Yes, Your Honor, and I would add to that the restatement of agencies, section 320, 230, I think I cited in the brief, which is in contract matters. And what he's claiming is that, the contract and the negligent misrepresentation, the breach of contract and negligent misrepresentation constitute the 93A violation. And so I think when we add the restatement, section 220, you have the cloak of the nonprofit, first, as you've pointed out, and also the fact that they're acting as agents. I think that strengthens that argument.
Thank you.
Thank you, Your Honor.
Thank you both. All right, this is the fifth case on for today. Oak Ridge Realty Trust against the Town of Lincoln Conservation Commission and the Headlands, 24P49. Mr. Angley?
Yes, Your Honor. Good afternoon, Your Honors. I'm here on behalf of the Oak Ridge Realty Trust in this matter, and I would like to sort of emphasize what the root cause of a lot of the arguments that we put forward in this appeal would be.
Can I interrupt you at the outset? And I'm sorry to have to do this, but I did not see a disclosure statement at any part of your briefing that would let us know who the Oak Ridge Realty Trust is, who the people are behind it. Is that information you can share with us?
The trust itself is consists of people of the neighbors to the Headlands. That's who the trust represents, owns the abutting property, and therefore are adjacent to the Headlands property.
Okay.
Not sure that's an answer to her question. I mean, if we're going to do conflicts check properly, I suspect our rules indicate that you have to identify who the principals are behind the trust.
The trustee is Windrock LLC, I believe.
Who's that?
It's a LLC out of
Oh, I
Delaware.
know. Who are the humans?
What's that?
Who are the humans?
Oh, the humans are, the trustee is the basic person is the people who live in the house next to the Headlands. So.
And is their name impounded, or is there some reason you can't say it?
No, that's how they had set things up. The owner's name is Alam Shapur, or Shapur Alam, sorry.
And are there any other individual humans who are implicated by either of these entities?
He lives in the house with his mother, but she is not, I believe, not part of the trust.
Okay.
You were saying there's one root thing.
Yes.
Root, R-O-O-T, not R-U-D-E.
Yes, yes, Your Honor. So the basic argument and the reason for the appeal of the Superior Court ruling is that it's our position, our feeling, that the Lincoln Conservation Commission did not act in good faith, but what they did is the delineation that's talked about in the decision and was originally before the commission did not meet the standards under CMR what a delineation should have. There were no field notes. The person who presented it on behalf of the Headlands was not a wetlands expert. The commission members, to my knowledge, are not experts in the field. When they went out and did the site visit, they went out in the winter.
Let me break this down. Number one, as I understand it, there was a field, they went out in the field to look at the property in 2017. Conservation Commission was there. A representative of your client was there. Representative of the Headlands was there.
Yes.
Okay? And there's a determination that it was agreed that the delineations were correct.
Well, the problem is that our expert did not actually agree to it. In fact, she produced a letter that said, I didn't agree to these.
When did she produce that letter?
That was after
When?
after that field
Give me the
visit.
date. How many years after 2017 did that expert say that?
That was within the first week or two after that.
It was?
Yes.
I didn't see any mention of that. What did she say exactly in the letter?
She was saying that essentially what happened was that they went out and they took a walk around in the winter time, which is not a good time to do a delineation because the water levels are not correct and the soil conditions are not correct. And that she didn't really agree with the position. She didn't say, oh yes, I agree, this is correct, this is the correct, this is correct. It was sort of people walk around saying, yep, it looks all good. Then when you actually look at the delineation, it's supposed to have field notes with where do we take samples.
That's the second component. So let me make sure I understand that. You're saying that there's some place I'm going to find a regulation or law that says this is what was required in terms of a wetlands delineation. And where is that?
That's in CMR, is it 310?
10.55.
Yes.
I'm looking at it. Where does it even mention what you were just referencing?
The mention that I was made aware of is that when we did
I was made aware of. I'm assuming you read the reg.
Yes, my understanding
Because
is.
you reference it multiple times as being what is the real problem here.
Yes.
So tell me where in the reg it says what had to happen that you say did not happen in 2017. And I'm sorry to be as firm as I am about it, but I have real questions about this case. Okay?
That's
so
fine.
where is it? 10.55. I'm looking at it right now.
Okay. 10.55, as far as my understanding,
Well,
from experts. I don't have the regulation in front of me, so if permissible, I'd be happy to do a 16L letter with the exact
No.
points. And so, okay.
I'll talk to my colleagues, but I don't think you get another chance to try to make up another argument. Okay? This is your argument, that 10.55 wasn't complied with. So you know what I did? I picked it up and I read it. And it doesn't say anything about specifics that I could find unless there's some attachment to it that I didn't see referenced. Okay? It talks about a credible source. It seems to me that if I'm the commission at Lincoln and I go out and I look at the property and I have representatives of everybody who's actually got concerns and they say, sounds right, looks right to me, that I've got a credible source. So what is it that's missing? The answer, I take it you don't have an answer to my question.
I don't.
Okay. What else would you like to tell us about?
Can I try, before you go, can I try on another one?
Sure.
You're suggesting that this should have been treated as a motion for summary judgment, yes?
Yes.
What's your best support for that argument on what we're looking at here?
I think the best support for the argument is that when taken into consideration that the fact that in our opinion, the delineation didn't meet the standards of what.
So it directly goes back to what Justice Englander was just asking you about.
Right, and that's
So
what
if
I'm
that's
saying.
not there, the whole thing collapses pretty much?
That may well be, yes.
Okay,
So,
go ahead.
and as I was saying, that my discussions with the DEP field agent, with Mr. Weisberg, who was a former DEP employee and instructor of their field agents, the discussion was that any delineation should have backup notes, readings, and whatnot, so you can prove your data, just like any sort of scientific report.
But the CMR does not say that. I have also read it. It talks a lot about vegetation and groundwater and, you know, what you need to look at, but I saw nothing in the CMR that required any kind of required that those findings be reduced to writing in any particular way. It may be that there's a best practice out there in the industry, but that's very different from saying it's required by the reg.
That may well be, and that may be what they're trying to refer to, is that if you're going to present a report, is that that I went out in the field, I took samples, I dug a hole, looked at the soils, looked at this is where I found it, I took a GPS reading, that this is where it was. You can go, take my readings, go out in the field, and you can verify. And that's what would produce a reliable report that's verifiable and repeatable. I think that that's where some of the deficiency of what was presented initially comes about. That there's, you or I or anybody can't go out there and say, well, this is where he dug this field hole. This is the sample that they took. Whereas the delineation that was performed later, all of those things occurred. We have the field notes. We can verify where the samples were. You can check check our work, basically.
So another question on the evidence. You cite a standing order, Superior Court standing order that requires, you say, the judge or required the judge to consider some additional evidence. And defendants respond, well, you didn't file your motion in a timely manner to present the evidence, so what's your response to that?
I think the argument was that the filing requirement within 20 days is not a file or to start the process within 20 days would seem a more applicable explanation, because it's impossible to get sometimes.
Did you start the process within 20 days? Did you file in other words, did you serve the request under 9A within 20 days?
I believe that we did.
Because when I read the briefs, you had not. Okay. We'll check that.
Okay.
I got another question about that. I looked in the record for a motion. Does the motion actually identify 30A 14.6 as the basis for it?
I think so.
I couldn't find it in the record.
Okay. I would have to check on that then.
Okay. What did it say? What did the motion to put in additional evidence, what did it say?
We were trying to emphasize that the information that was presented to Lincoln Conservation Commission back in 2017 wasn't accurate, wasn't complete, and that with this new information that should be considered, because now that the DEP had gone out and said, we agree with these findings.
Okay.
And
I get that, but 14.6 has several requirements. It has 3 elements to it, and the second element of 14.6 is that you show, I think the words are good cause, that you didn't put the evidence in at the time that of the administrative hearing. So I'm jumping past the question of whether 14.6 even applies to certiorari. The judge said it didn't. Let's leave that. That's a legal issue. Let's leave that aside. Assuming 14.6 applies, you have to show good cause for why you didn't put it in back at the time. Was there in your motion? Did you address good cause, and what was the argument?
The good cause would be that at the time, from our conversations with Matt Schweisberg, is that the time of the year was not appropriate to do a good delineation. And so when we went and got the work done, which I believe was in the spring, which is the better time to do it, DEP came out, the commission came out.
Spring of 2018?
Yes.
Because the presentation wasn't made until 2019 sometime, right?
Yes, we submitted, the information was submitted to the DEP, and it sat, and it sat, and it sat, and
But your presentation, your expert's presentation was not submitted to anybody till 2019, is my understanding. Am I right about that?
Yes.
So forget about it sitting with anybody. It sat with you. 2017 is when the decision is made. 2019 is the first time that you come forward with new evidence. And the good cause for that 2-year gap is?
As I said, well, when the 2017 hearing was in November, December, so now we've rolled into 2018, and then it took time for be able to get the experts to be able to get out there, do the field work, coordinate a time with DEP to be there with us to make the observations, and then it took quite a long time for them to respond to us.
Was any notice provided? Where am I going to find in the record that somebody said to the Lincoln Conservation Commission, hey, you know what? you relied on the wrong information back there in December of 2017, and we're going to work really hard to get you the right information. Where's that? Where am I going to find that?
I think the notice was that they came out and they did the field study with us. We all came out and looked at the property and walked around in the woods.
Spring of 2018?
Mm-hmm. Yeah, or a little bit later, because as I said, it took time to coordinate with Mr. Abel to actually be able to come out and do a site visit.
Your position that is it your position that the Lincoln Conservation Commission had no discretion to approve the building between 50 and 100 feet into a buffer zone?
Yes, it's our position that the...
What do you rely on for the no discretion? You rely on section, whatever it was, 7.8 of the bylaws?
The bylaw itself doesn't add or doesn't allow discretion. It simply says no.
It says may. Where does it say no?
What
are you relying on?
That was our reading of the bylaw. Is that
what are you relying on? What provision of the bylaw says they have no discretion with respect to building between 50 and 100 feet from a wetland? Because I read it, and again, I couldn't see it. I'm looking at 7.8 of the bylaw. In order to avoid adverse impacts to wetland resources areas and upland buffer zone resource areas, the Commission may require all permanent structures to remain outside the upland buffer zone resource area. May. That's not will.
Is that the 2017 version?
Yes. Appears to be, as I have April 2017 at the bottom of the page.
Okay.
Although I can tell you that I'm no expert on the Lincoln Conservation Commission bylaws.
My reading of the bylaw was that there wasn't discretion.
Okay. Do either of you guys have?
I'm all set, thank you.
So, does this court have discretion to award fees against you when they have not been requested by the other side?
Not to my understanding or belief.
What would you cite? Tell me that we don't have the discretion to do that. Rule 25 doesn't say anything about it. I can tell you that.
That it doesn't have to be requested?
Yeah.
It
says that that in fact there's a case that says we can do so sua sponte.
If that's the case law, then that's the case law. But my understanding of the American judicial system is that that's not how it operates. Unless you request attorney's fees, then they're generally not going to be awarded. It's not an automatic as in other countries.
No, I'm not suggesting it's automatic. It would have to be a finding under Rule 25 that the appeal is frivolous. We'll hear from your sister.
Good afternoon, Your Honor. Donna Brewer for Jonathan and Holly Headland, and I'd just like to say Mr. Headland is here this afternoon. So I believe that Your Honors have emphasized the point that we are here today. In 2017, November 2017, Holly Headland first went to the Conservation Commission Director and asked if they had any issue with a wetlands delineation. He went out in November and told her no, it looked fine. A few days later, the abutters, Oak Ridge, filed with the commission seeking a determination of applicability. In December, there was indeed a site visit, and the site visit had two staffers, the commission, the Headlands, a representative for the abutter, and two wetlands experts whose expertise has never been challenged.
Well, two wetlands experts being one from each side?
Correct.
Okay.
Marianne DePinto for Oak Ridge and David Burke for the Headlands. As the minutes reflect, and as the administrative record reflects, they all agreed on where the placement was, on site.
Well, by the placement, you mean the 100-foot buffer zone from wetlands?
Correct.
Now, so if I look at the administrative record, I'm going to find all parties agreed in the record itself?
Yes, actually in the record appendix, volume 2, 158 to 160, are the meeting minutes of the Conservation Commission on December 13, 2017, and it states that the commission agrees that at this location, the online GIS mapping is not exact and agrees with the two wetlands experts that the field delineation of the wetland is accurate.
You have a page, I'm looking at it. Just, can you give me the page on that if you have it?
Sorry, it's Record Appendix, Volume
for
2,
interrupting.
page 158.
Thank you. Sorry.
Agrees with the two wetlands experts. So you
Correct.
take that as a reference. Now, your brother says, within a week, Ms. Pinto sends a letter that says, hey, I didn't agree. What do you say to that?
Frankly, I haven't seen that letter, so I don't think there is a letter that says that. But if there is, I will say that that is contrary to what was presented at the hearing, and the hearing had closed as of December 13, 2017. So there was
Wait, what was the date of the field examination, November?
December 12th.
12th, and then they had a hearing of the Conservation Commission at 13, and you say that there was a presentation there that that Ms. Pinto agreed?
Wetlands experts David Burke, representing the Headlands, and Marianne DePinto, representing the applicant, were also in attendance. Observations were made in the field that the wetlands delineation as shown on the survey plan of record is correct.
Those are
And then the line
observations
that I
in the
read
field.
before.
I thought you were telling me that Ms. Pinto, that there's someplace in the record an indication that Ms. Pinto agreed at the hearing itself the next day.
No,
Commission agrees that at this location, the online GIS mapping is not exact and agrees with the two wetlands experts that the field delineation of the wetlands is accurate.
Yes. Yes, that is it. And then, as we have going on, actually, Mr. Angley, who was there at that hearing on December 13th, Mr. Angley believes that the plan should show flags, numbers, and should be at 20-foot scale. Flags hung by David Burke were verified by survey. Numbering of flags on map at 20-foot scale will be provided. And then the record includes a plot plan with the buffer zone showing at 20-foot scale that was presented to the commission later in December as requested.
That plot plan in the record?
Yes, that's
I
it.
assume it shows the paddock and the barn are outside the 100-foot buffer zone.
Correct. It's Record Appendix, Volume 2, page 148. It's actually, as you might imagine, there are several places in the record.
But what do
where-
we do with the fact that he says then, within 6 months, they come back, apparently with the Conservation Commission in tow, and take another look and do another set of tests or another set of measurements?
That was all part of the appeal to the DEP, seeking a superseding finding, a determination of applicability. It was not as part of the Conservation Commission action, which was closed as
Am
of...
I right that the state regulation is a 50-foot buffer zone, not a 100-foot buffer zone?
Correct.
And that's why the DEP says, well, we don't have a problem with this because it's outside of 50 feet.
Right, right. The DEP did not have a problem with it, and there was no appeal of the DEP finding. I'll say, I do want
Is
to...
there at any time, if I look at the record, am I going to find a reference to what your brother says, which is that there was an argument being made that what happened in November or December was not as effective a way to determine wetlands boundaries because it was during the winter? Is there a reference to that anywhere?
No, Your Honor.
Can I ask an outside-the-record question, which, of course, we will not rely on your answer in considering and reaching our decision? What is the status of the project now?
It's been done for years. The barn has been in place, the paddock has been in place.
Was it in place in 2017? Was it already
It
there?
was being constructed in 2017.
Yeah.
Are there horses?
2 horses. They're permitted to have 2 horses.
And if I'm just kind of passing time while Justice Englander formulates his next intelligent question, which is distinguished from mine. I'm looking on page 148 at the map. Am I correct in understanding that it's
do that to
kind
me.
of the, no, you're always good. The bottom left corner of the paddock that's within the wetland zone on this map, in other words, the part near the apple tree?
Exactly, Your Honor.
Okay.
Yeah, that's the small amount of fencing that they do note is part of the 100-foot buffer, but outside the 50-foot buffer. And as noted in the meeting minutes and in the record, the commission and the commission director noted that the commission has in the past allowed some work in the zone between 50 and 100 feet.
So they filed a motion, which I couldn't find, under 14.6, and the judge said, well, 14.6 doesn't apply. And as I said to your opponent, let's leave that aside. Did the motion have an explanation of the good cause for why it took them 2 years?
No, Your Honor. I think, in fact, he wasn't really going under 14.6 because, of course,
Does it reference 14.6?
it doesn't. And the reason it couldn't.
Motion does not reference 14.6.
No, Your Honor. He just asks to present additional evidence, and I think the reason he did that is, of course, there can be no good cause to have not presented this evidence in 2017 because it didn't exist. So there's no possible way to put it under 14.6 to supplement the administrative record for something that didn't exist in 2017. Instead, I think what he wanted to try to do is turn this into an ordinary summary judgment case in which one can go beyond the record but provide affidavits, as he does, to try to raise an issue of fact that should cause this matter to be remanded. But of course, that's not a certiorari case. That's not what we do in certiorari cases.
To Justice Englander's earlier question, you did not request fees under Rule 25.
I did not, Your Honor.
Okay.
Why not?
Thank you.
Honestly,
You asked the
Your Honor,
intelligent question. Yeah.
it's not my practice to do that. I very rarely, it's just not
Well,
not
fees
my
are very rarely awarded.
They are very rarely awarded. I did not do so in this instance.
Is there anything am I missing anything? Is there anything in 310 CMR 10.55 that's going to tell us that what you did in 2017 was contrary to the reg?
No, Your Honor. I mean, I do have the reg in front of me, and it
Credible
does talk
source, right?
Sorry?
It says credible source.
Credible evidence to be,
That's
shall
it.
be submitted by a competent source.
Yeah.
And the issuing authority must evaluate vegetation and indicators of saturated or inundated conditions if submitted by a credible source. Yes, it does. And in fact, the letter that is in the administrative record from David Burke does just that. He notes where the wetlands were flagged, he notes soil conditions, he notes vegetation, and he specifically says that his letter report was in place of the DEP data forms. So we have in fact complied with that.
Turns out he was wrong, though.
Sorry?
It turns out he was wrong, doesn't it?
I'm not sure he
says
was.
56 feet.
I'm not sure that he was wrong, Your Honor. I think, if you're going to find one expert and she tells you that David Burke is right, I can probably go find another
Well, it seems to
expert.
me there's a big difference between 56 feet from a wetlands and 100 feet from a wetlands. 15 yards, to be exact.
True, yes. One of the other things I wanted to point out, though, of course,
That's
is...
odd. So let me ask the next question. Even if the evidence that they wanted to put in were accepted, that in fact it was only 56 feet setback from the nearest point, which I think is really just a fence of the paddock, would the Lincoln Conservation Commission have been required by its bylaw to say that the proposed building was not allowable?
No, Your Honor. And of course, we're here on an arbitrary and capricious standard.
Well, I completely understand the standards. I'm just asking the question. Because
Yeah,
they
no-
suggest that it would have been, that there was a failure to take an enforcement action that they were apparently, the argument is, required to take. So I took a look at the bylaw, and I couldn't see it.
Yeah, there is no requirement to enforce a bylaw in any case. For a town just simply isn't required to do that. And in this case, both the Lincoln bylaw and the wetlands regulation itself are they just require information to describe the proposed activities and their effect on the resource areas. They don't require anything specific in the nature of these affidavits from these experts. They don't require anything under oath. They talk about shall contain data and plans sufficient to enable the Commission to identify and understand the proposed activity and its effect on the resource area. And that's what they did. That's what they relied on. That was present in 2017, and there's actually no dispute in 2017 as to the extent of the wetlands, the extent of the buffer zone, and the extent to which this project was in the buffer zone. There's no dispute about that.
Anything else you want to tell us?
No, Your Honor.
Do you want to request fees?
Yes, Your Honor.
Thank you both. Thanks to everybody. Thank you, Gio. And thanks to the people who handled the clock, et cetera. And we are done for the month.